or the government is allowed to
It's
force
such
you
a
to get an
fucking
abortion.
ludicrous position. Can we stop
Yeah,
with that?
I think
Like,
that's
that is so stupid.
Wait, why do you think
What is
it's so ludicrous?
I don't think it's too much to ask.
Okay, wait, hold on, wait. One of the worries of the Alito draft is that this could theoretically be used, even though Alito says otherwise, I think like 4 times, this could be used to get rid of a lot of contraception. So I'm curious if you really believe that. If we were to say theoretically that there was a pill that you could take to have an abortion up to 9 months, would you be okay with like a 9-month abortion if you took a pill for it?
So how do you delineate that? It might not be life.
Is a fertilized egg a human being?
I didn't ask if it was a human being.
Okay, I think. Hold on, wait. Let's.
Yeah,
So wait. Hold on. Whoa, hey. Alito just recently had a leaked opinion that nobody cares about the leak, I guess, but they care about the opinion, which is a different thing. But basically, it looks as though the court is poised to overturn Roe v. Wade. Now, historically, I say historically, over the past few years, I've heard people make arguments that the Roe v. Wade ruling and the Casey ruling are on kind of shaky ground in terms of how we arrive at this right to abortion. I've heard other people say it's not shaky ground. I'm not here to make those arguments. I'm kind of here to bring you guys together who are all, I believe, currently practicing attorneys, right? So
yeah.
I swear in June.
Okay, whatever, close enough. Okay. And then I'm kind of curious to hear the back and forth on. There's like 2 big questions, I guess, that I have. One is if you think they're two. I think they're fundamentally different, although they get conflated. One is if you think Roe and Casey were good rulings, and then the second one is, regardless of if it was good or bad, do you think that the court should overturn these? Before we start, I guess, like broadly speaking, can we kind of move through? I'm just curious so that we can all kind of get down. Lego Pizza. Do you have a name you prefer?
Say that again. I'm sorry.
Lego Pizza. Do you have a name you prefer? Or do you want me to call you Lego?
Lego's fine.
Okay. So Lego. Broadly speaking, how do you feel about Roe v. Wade, Casey v. Planned Parenthood? Yeah, and then the Alito draft.
Sure. So I think personally that Roe v. Wade is actually a compromise between the pro-choice and pro-life sides, because if you look at the pro-life side, they say abortion should never happen. If you look at the pro-choice side, they say, you should be able to get an abortion whenever you want. And then when you look at the actual rulings in Roe v. Wade and Casey versus Planned Parenthood, they've delineated when an abortion is okay and when it is not okay. And that ends up being when the fetus is viable outside of the mother's womb, when you look at what Casey says, right? So I think that that's actually just a compromise, and we should be happy with that as law, because it's some middle ground, right? I mean, this is going to be something in America that people are going to fight over forever. Mm-hmm. And when you look at it like that, I think that Casey and Roe kind of show you this compromise that we should be okay with. I disagree that there is some like shaky ground on it. I think that they've used law that they've used before in other implied right cases, and it's consistent with those.
Okay. And then, so you would say that Alito's overturning it is a bad thing, I'm guessing, right?
Yeah, and I don't agree with Alito's overruling of both. I don't think that there was enough factors that would overturn the precedent in this case. I mean, we can go through a stare decisis factor if we want, but also I think that the foundational law is good law and isn't proper to overrule, even if even with stare decisis factors, because it is foundationally sound.
Okay. Pisco, where do you stand on Roe and Casey, and then on Alito's overturning of such?
Yeah, I think that Roe stands as totally consistent with a line of cases in the 20th century that recognizes implied fundamental rights. And that's basically what you have to do to accept Roe, to accept that fundamental rights exist and that Roe is in line with cases like Griswold, with cases like Eisenstadt, Skinner, that recognize that there is some notion, some implied liberty about the autonomous decision whether or not to bear or beget a child. And that's how you should view of that right. Why should you believe that implied rights are a thing? Well, one is the Supreme Court says so. And so for years, substantive due process has been the law of the land. Alito recognized that substantive due process is the law of the land in his draft opinion with respect to the incorporation doctrine. those are kind of implied rights that no one thought applied to state governments until later in the 20th century, when we interpreted those rights to apply to the state governments. But also, it makes sense. The Ninth Amendment of the United States anticipates that there's going to be some exercise along the lines of identified and implied rights. And the question ultimately is, how do you find those implied rights? I agree fundamentally that the inquiry is one of history. History is your guiding light here. But it's not at the level of the narrow set of individual circumstances that existed in the 18th century or in the 19th century. It's more valued in principle than that. We don't want to live in a world, and we don't live in a world where the government has ever been allowed, for instance, to tell you that you must that you must get an abortion. Think about that example. If there were a world in which a state passed a law that said you must have an abortion, if there is no if there is no fundamental right on the decision whether to bear or beget a child, that law seems like it would be perfectly constitutional. Of course not. History tells us that that value is intrinsic to our notions of ordered liberty. And for that reason, Roe is not an aberration. It's a continuation of the cases related to contraception and sterilization. Is it the perfect opinion? No, in terms of maybe some of the line drawing that's done in that case and some of the atmospherics, but on the substance, it was correctly decided. And we'll get into stare decisis later, but that's kind of my take.
Okay, gotcha. All right, just looking for quick overviews, motherfuckers. But now that we've gone this far, might as well hash it a bit more. So, okay, Nick, yeah. So, what do you think about the Roe and Casey rulings, and what do you think about Alito overturning said rulings?
The Roe and Casey rulings are terrible. They're bad law. They've always been bad law. They've been recognized as bad law by such firm pro-life Supreme Court justices as Ruth Bader Ginsburg, the proest of life justices out there. They recognize that Roe is a made-up implied right. It always has been a made-up implied right. It is a completely different nature and character of implied right than all of the other implied rights that we have. It disregards one of the most implicit rights in the Constitution, which is the right to life. If we want to start going through history of cases, if we want to start going through the history of how these things are viewed, how implied rights are viewed, we can go all the way back to English common law in the 1400s and find an implied right to life and an implied set of rights being granted to unborn children through property law and through descendancy. So no, they're terrible laws, and Alito overturning it is entirely proper. And I know we're going to get into this debate about, well, should it have been overturned? It's precedental. Do we meet the stare decisis factors? And the biggest stare decisis factor is, was the foundational ruling correct? The foundational ruling was not correct. Therefore, it should not be there. Therefore, the stare decisis test is effectively met at this point. The argument in favor of Roe has always been, well, it's precedental, so therefore it shouldn't be undone. But that's not really solid foundational grounds, and so no. I will always disagree with it. Whether or not you believe abortion should exist in some factor or another, Roe was an improper vehicle to get it there, always has been. And yeah, I guess we can debate from there, but that's my opening position.
And then Jesse, your opinion on Roe and Casey, and then your opinion on Alito overturning Roe and Casey.
Yeah, I think my position's a little bit more attenuated on the first issue, at least. I generally seem to think that the differentiation between enumerated and unenumerated rights is a bit of a red herring, in my opinion. I think all of our rights are essentially implicit in ordered liberty. Free speech as text doesn't really mean anything. So, like, I can't really understand a principled way to say burning a flag flows from the text of free speech any more or less than abortion flows from the text of due process. I think they're all kind of against this implicit and ordered liberty concept. So we have to go to history and tradition, which means the common law. So my personal view on it would be that the common law definitely has privacy flavors in it. Abortion looks like it fits within those privacy flavors, but we look at the common law to see if there were countervailing historical considerations that cut back against that. And it seems that at the very least, quickening fundamentally changed what the common law thought of for abortion. So I think that the most principled line to draw would probably be whatever the common law demanded, which seems to be quickening allowed the state to infringe on these rights. And before that, it seems to fit a lot more with this like marital privacy or privacy that we have. And I think any other line is going to be either overbroad, such that everything is a right, or underbroad, such that we lose marriage and contraception. So again, the stare decisis question is a different one. I do think it's a little bit harder than was it wrongly decided, but I do agree that the extent to its wrongly decidedness is the key. So if there is no right from conception onwards, then it probably should be overruled. If the right does crystallize until quickening, it probably shouldn't, because I don't think the reliance is nearly as strong there. So we can get into that, though.
All right. Well, I guess before the Alito ruling is going to be a separate thing. I guess let's start like fundamentally this idea of Roe and Casey, the idea of substantive due process and these unenumerated rights. How, I don't know how you guys want to do this. Who wants to go first? There, how will we do that?
Yeah, I think it would be helpful to like ask some questions the other side and see how they respond to that.
Yeah, go for it, because it seems like Nick is a little bit of the odd one out here, and that Nick seems to be the one that strongly disagrees. We've had a conversation, Pisco, about basically like, you know, like should there be unenumerated rights at all if it's not explicitly spelled out? Yeah, so I guess maybe if you and Nick and the other guys want to bounce around a little bit on that, I'm curious what your takes are for that.
Yeah, I think the first step, you're absolutely going to reject Roe and Casey if you don't believe that there is such a thing as implied rights. Now, you could have a different source for where those implied rights come from. You could say that it comes, as Thomas does, from the Privileges or Immunities Clause. You could say that it comes from penumbras, if you're going to accept the majority opinion in Griswold. Or you could accept what's now sort of the Academy's position, which is the Fourth Amendment's Due Process Clause. But that's the first and principal question for the other side. Do you believe that the Constitution allows for and actually embraces implied fundamental rights?
Yeah, obviously.
Okay. In which case, so some of these, everyone here would agree, are the Bill of Rights, the incorporation of the Bill of Rights largely to apply to state governments. That's right?
Are you asking if the 14th Amendment applying the Bill of Rights to state governments is correct?
Yeah, that's one of the areas of implied rights.
Sorry, okay. I was just clarifying that I understood the question. Yeah. I mean, correct. We can get into a long discussion about Reconstruction. I don't think that's the appropriate time for it. But yes, for the purposes of this discussion, yeah, sure.
I would agree too, but I think you get there even without the Bill of Rights. I think that you can look to the common law to get to these answers, whether or not there is enumeration.
So you believe that the Bill of Rights are surplusage?
I mean, I intend to believe so. Yeah, I mean, I think Hamilton largely thought that as well. It's like,
wait, can we? For some people in chat don't know what you meant when you said surplusage. Can you explain that for the people in chat?
So, what I'm hearing from from Jesse James, from Jesse, sorry,
no, you're
from
good.
Jesse, is that the Bill of Rights is not even needed to apply the Bill of Rights to the states, and that you don't need, it's surplus, right? You don't need the Bill of Rights to identify those rights as applying to the state government. And that's the position that I don't know it's not a majority position, I'm sure, and one that I assume Rekieta doesn't accept.
Yeah, I want to just be really clear on what I mean by that. I'm saying it's not needed. That does not mean that it's not helpful and serve a very foundational purpose. So like the Alito opinion talks about this as well, but this is how we largely view rights as well. The Timms opinion and the McDaniel opinion, even though they're quote unquote enumerated rights, we go to the common law to figure out what does the right actually mean. So all the Bill of Rights really does is it says, hey, just so it's clear, these rights definitely exist, but you still have to go to history and tradition to figure out what those rights are. So
that seems like
yeah, go ahead. Sorry.
That seems like a maximalist interpretation of implied rights. And I just want to put a flag here for the audience. Anyone who says, well, those abortion people, the people who are in favor of Roe v. Wade, they're in favor of reading rights where they don't exist. They're in favor of this extra textual stuff that we're not doing. Notice the answers so far from both people on the other side. They both say that they were going to find implied rights. And what Jesse even says that you don't even need the Bill of Rights. That we can find rights whether or not there are a Bill of Rights.
To be super clear, what do you think the Ninth Amendment does?
Yeah,
and also hold on, just for guiding this
into the Bill of Rights.
Yeah, and then hold on, just to guide this, and then I'll give Nick and the other guy a chance to respond. Nick and Jesse. I shouldn't say the other guy. Sorry. Before we start hammering out huge positions, I imagine both of these guys are going to provide what they believe is a foundation for why abortion is going to be like substantially different than other implied rights. I imagine is what we're going to get into. Yeah. So. But
Jesse, the act of finding implied rights is not one that's unique to the Roe position.
True, but I think everybody here agreed that there are implied rights as part of.
I just want to be clear. Yesterday, I had a debate with someone who denied, or at least denied a huge part of that, and said they should all go. Griswold should go.
Well, listen, it's not yesterday. We're in a new conversation with new people. Yeah, I think everybody.
But it is useful to suss that out as a position, because there are some people who will say no, implied rights. Yeah. This is all cockamamie.
Okay, Jesse, and then Nick, go.
I think you're 100% right that like there are definitely people with all sorts of positions, but I mean even Justice Thomas some degree believes in some kind of substance. But I generally think that the Glucksberg opinion is the way that we should do this. We should look at the history tradition. We should look at what sort of historical state interests pushed against these rights. And I think that if the Ninth Amendment is intended, if we can understand it to mean anything, we have to understand it to mean that there are rights outside of what's here. And I think all the Bill of Rights, I shouldn't say all, that's a bit reductive, but I think the main thing the Bill of Rights does is it provides a very solid jumping off point to crystallize what the common law already provided with respect to a lot of these rights. I don't think that that's even a particularly controversial thing, because we go to the common law to figure out what speech is, and we go to the common law to figure out what the limitations on the right to bear arms are, everything else. So even if we never had a Bill of Rights, I think that there is a mechanism to, well, maybe not if there was no Bill of Rights, but even if the individual rights in the Bill of Rights weren't enumerated as they are, I still think there's a mechanism to get them. Even if all we had was the Fifth Amendment due process and the 14th Amendment, I think we'd still get there.
Let's run it down.
Well, no, wait. Let's give Nick some input here. Go.
No, I'm going to largely argue or agree with what Jesse is saying here. I mean, again, the fact that implied rights are enumerated themselves within the Ninth Amendment shows that implied rights are intended to exist within the Constitution. I think the Ninth Amendment was the compromise position between the people who wanted the Bill of Rights versus the people who did not want a Bill of Rights. They were concerned, as they should have been, that only enumerated rights would be respected and honored. What their, of course, big miscalculation was the idea that the enumerated rights would be respected at all, which they barely are. It's comical to think that enumerated rights are actually respected in this country and have been respected by the Supreme Court. But that being said, implied rights clearly exist. They are broader than any of us want to imagine. It's just as Destiny accurately predicted, there is a foundational difference between what the idea of an abortion right would be versus, say, a right to privacy that exists in looking at the Fourth and Ninth Amendments combined. Otherwise, we can take an implied right to security in the effects of our electronic documents, right? Something they had not specifically written down at the time of the Fourth Amendment, but we recognize that, yeah, if you have right to privacy in your papers, you probably have right to privacy in a virtual paper that didn't exist at the time. But that is a far cry from saying you have a right to terminate a pregnancy that is implied anywhere in the Constitution or anywhere in the common law.
Let's talk about why.
Well, hold on. Before we jump from that, though, I do, because basically I think we are all sort of agreeing that framework here is history and tradition. I don't think any of us are really pushing back on the idea the common law is the push there. And like I said, I generally tend to think that the Roe right is largely correct, except for the fact that viability is not principled. I think quickening is a lot more principled. But I think, why on the
it's a Roe is rightly decided.
You think quickening is more principled than viability?
Well, because he was saying if you could look to the history of the common law, quickening is something that's explicitly referenced.
Yeah.
I think viability is completely foreign to the common law. If we're going to go with common law as our guiding principle, I don't think we can go with viability. I think that's different. But
to be clear,
the point that I wanted to drill down on.
You accept the central holding of Roe that there is an individual right to abortion. You just disagree on where the state's interest crystallizes.
Exactly. Well, I don't even think there is a disagreement there. I think Alito explicitly in this opinion says
there's a disagreement between you and Nick Rekieta, which is
I'm a third party here, so I'm going to be arguing against everybody probably. But I do think for the pro Roe people, though, I think we need to try and figure out what your limiting principle is. Why don't I have a fundamental right to contract such that I have to have a minimum wage? Like what how do you distinguish your
Lochner?
limiting principle? Yeah, we don't have to specifically do Lochner, but anything, right? Like anything we can make up. What is the limiting principle?
Well, we just talked about it. We said that history is our guidepost here, and we look to rights that are so intrinsic to our notions of ordered liberty, and which have always been respected at some level of abstraction, not at the particular practice itself, but at the essence of it. What is it getting at? And that's why I'm going to ask you guys whether or not you agree with Griswold, and whether or not you agree with Eisenstadt, and whether or not you agree with Skinner in the sterilization case.
Can I, just for chat, when you bring up a case, can you briefly summarize?
Yes.
So Griswold, I think, was contraception.
Griswold is contraception. Yeah. And by the way, these cases for married people. Eisenstadt is for unmarried people. I think there's a case called Carey as well later on, which applies beyond the marital bedroom. And
that has minors, like 16-year-olds.
And the Skinner case has to do with using sterilization, I believe, as a criminal punishment, and has been understood later in time to put limits on the government's ability to sterilize you. And so I'm asking them, given this line of cases, this precedent, and really given the how much it would shock the conscious to say something like the government is allowed to force you to be pregnant, or the government is allowed
it's such a fucking ludicrous position. Can we stop with that? Like, that is so goddamn stupid.
Wait, why do you think it's so ludicrous? Do you not think
the government could force? Oh, so we're gonna have government rape camps running around? Look, lady, it's your time of being pregnant. We're gonna.
I agree with you, Nick. I agree that
if you said remain pregnant, there'd be a lot less loaded language, and then we can keep having the conversation, right?
Let's actually talk about it. So if the government were to say we're going to force every 20-year-old on our timetable to get pregnant and to forcibly inseminate these people, what would be unconstitutional about that?
I mean, a shitload would be unconstitutional about that. I agree. I don't understand.
But what?
I don't understand. Like that's like the idea of saying, well, if we got rid of the right to free speech, then the government would have a right to compel speech. But it doesn't have a right to compel speech, even without the freedom of speech.
I agree. I agree.
So
I think the common law is really clear on that.
But let's talk about where the difference in the First Amendment case is. In the First Amendment case, everyone agrees that there's a right to speech. And therefore, the corollary of the government can't tell you to shut up is the government can't tell you to speak. In this case, you're denying that there's an abortional right, that there's a right, a decisional right on whether to bear or beget a child. And so but at least Nick Rekieta is. And my question for Nick is, what aspect of the Constitution, I'll repeat it again, would make the law of forced pregnancy unconstitutional under the United States Constitution?
I mean, the idea that just consider, first of all, we've all accepted that there are implied rights. But again, the hyperbolic position of the government can come around, pump semen into you, and force you to be breeding stock is so far beyond the scope of just saying, look, you made a choice to get pregnant. Now you can't kill the baby that's inside because it's a life. The forced creation of a life is different than saying you don't get to terminate a life. Something that even in Roe, they recognize there's some level of interest in that potential life. You're looking for some specific language in the Constitution that says, actually, you can't run around and have a government penis pump semen into someone against their will. I mean, come on, man.
Like, not language, though, just a limiting principle. We can say it's different.
The basis is? I mean,
we can say it's different, but why is it different?
We all agree that policy would be atrocious and reprehensible, and I agree that it would be unconstitutional. I just want to assure you of that I believe that law would be unconstitutional. But I believe that it would be unconstitutional because I think people have a right on the fundamental decision about whether to bear or beget a child. But where do you draw the source of constitutional? I mean, you might be able to distinguish later on abortion from forced insemination on the state's interest analysis. But at the right stage of the analysis, what is the source for saying that law is facially unconstitutional?
we have a fundamental right to life, liberty, and the pursuit of happiness. Right? Like that's
Well, hold on, but that's not actually what is happening in the case of forcing someone to bear the child, right?
Why not?
And I can give you a hypothetical on this. So let's say you have a 5-year-old child, right? And they have kidney failure, and you're the only person who has a compatible kidney. If you donate one of your kidneys, you will 100% save the life of that child, and you will have a 0% chance to die. Should the government force you to donate the child?
No.
Okay, so you're saying that there isn't a right for a child to use the parent's body in order to live.
Well, for your hypothetical to work, you'd have to
in the case
both
of
be in a
forcing
car
the
crash.
woman to use her uterus to have the child.
Yeah,
It's
but the only way that
exact same
hypothetical
thing.
works is if it'd have to be mom and son are in a car crash, they share a blood type, and when they wake up from their coma, they're already connected. And then it's a question of, can we cut the cord?
We just want the source
that's-
of the constitutional right at issue. I
Yeah,
don't think it's too
we
much
have to go
to
with the
ask.
hypothetical.
Okay, wait, hold on. I'm gonna pump the brakes. Okay, so philosophically, and I'm almost positive, legally speaking, we would all agree there's probably a difference, even if both are bad, between causing harm versus allowing harm, right? If I hold somebody under a pool and let them die, which we could say is abortion, that's going to be different than if I watch somebody die that's drowning that I could save otherwise by donating a kidney, right? So these are probably fundamentally different, even if we would agree that both are bad. So I don't know if it's a one-to-one comparison here. I will say that on the second hand, rather than coming at this from like a limiting principle thing, I'm curious, can we start at the other end and then Pisco and Lego, can you guys construct this, like, give me this right to abortion, and then I guess for Nick and then maybe Chessie, like once they've started to imply too much, can you tell me where, like, you would say, like, you need to stop right here because now you've gone too far? And the reason why I'm asking this is because, like, some of the language, Nick, that you use when you say things like the state has an interest in potential life, one of the worries, we're getting a little meta, but one of the worries of the Alito draft is that this could theoretically be used, even though Alito says otherwise, I think like 4 times, this could be used to get rid of a lot of contraception, because contraception that involves the fertilization of an egg is potential life, and now we're arguing that the state has an interest here, right? So I'm curious if, like, Pisco, can you begin to construct that right to privacy abortion?
Real quick on a defined term thing, though.
Sure.
I think birth control can be post-conception. Doesn't contraception literally mean stopping conception? This is totally semantic, but I think it's worth, like, noting at least. I agree there are types of birth control that will prevent attachment after conception, but I don't think there's any contraception that happens after conception.
Yeah, but I mean, like, arguably, this could be part of the
wrong.
argument, right? Like, some people might say, like, should the Supreme Court be taking a position on differentiating these things, right? Like that. So
Yeah, I totally agree. I totally agree.
I would say that things like Plan B are kind of in this gray area, right? Because a lot of women take Plan B without knowing if they actually are pregnant or if there was actual conception. So you have some sort of like Schrodinger's baby, and then they take Plan B so that they can avoid the pregnancy. But there's a chance that they don't actually have, they might not have actually had a conceived fetus yet, right? Like there might not be a fertilized egg, but they still take it.
Yeah. Okay. Start building. Or Nick, go ahead if you want to say something.
Real quick, I'll make my position up front before it gets assumed. There is, to me, there's a distinct difference between contraception or even abortifacient usage versus employing someone else to shove a vacuum cleaner into your cervix and pull a baby out of it, right? Like there's a difference there between taking a pill and having someone actually go in and remove something, employing someone else to do so.
Wait, can I ask a question on that? Because I'm curious if you really believe that. If we were to say theoretically that there was a pill that you could take to have an abortion up to 9 months, would you be okay with like a 9-month abortion if you took a pill for it?
Would I be okay with it versus do I think it's legally defensible? I think it's much more legally defensible for a court to find that, or for, I guess, a permissive right to take an abortifacient even up to 9 months than I do thinking, then I think it would be in the federal government's interest to allow the employment of a doctor to perform some sort of procedure. Obviously, the closer you get to I guess, delivery, right? So if we're talking an 8.5 month abortificant, like unless it liquefies the baby in some sort of way, but theoretically, if that were possible, I think that's a different discussion.
Yeah, sure.
But
I'm
again,
just curious because in terms of what you said, it sounds like a doctor performing an abortion on a 1-week-old fetus would be bad, but a woman taking a pill at 9 months would be more defensible. So I was just curious on that position. But yeah,
I just think there's a big difference in the privacy interests involved. And I think if we're going to go down the line of privacy interests, which is what I have a feeling most of the people on this panel see the abortion right as some sort of fundamental privacy plus autonomy interest, then we have to look at every single other privacy interest. We got to go to cats. We've got to go through that entire line of cases where once you are sharing that privacy with a third party, then the government has access into that privacy. And though I disagree fundamentally with that concept and how it's used to monitor, say, bank accounts or phone calls or whatever, it is part of the jurisprudence of the United States. It gets left out of this discussion every single time. But we are getting a little bit out of scope here, because the question is not whether or not abortion should be okay. The question is whether the government, the federal government, needs to enshrine it as a fundamental right that is not reserved for state action. And so I know I'm going to probably be mislabeled in the audience here, and so let me just make it clear. I think if a state wants to enable abortion, actually, I shouldn't say if a state wants to make abortion legal, because abortions are presumptively legal and have been presumptively legal except when they were not, which is right before Roe, incidentally. But if a state wants to make an abortion illegal, that should be the state's choice, not the federal government's choice.
Okay, so then I think this circles us back to my question, I think, for Pisco, which was, can you construct that right? Yeah.
Absolutely. Yeah. Though I want to plant a flag here, again, second flag, okay, which is there are two steps to this analysis, which is going to be first assess the fundamental right and to the extent that it exists. And next, we're going to assess a state interest to see when and where that right can be usurped or infringed upon, whatever.
Can I jump in real quick, just because this is what I had originally emailed Destiny about. And
a simplification, okay?
Yeah, no, totally. But I would like to kind of just make sure from first principles we agree, because I basically, like, in the equal protection, where all of the equal protection clause stops certain classifications, just by way of background, the way that the framework was developed was you figure out what the classification is first in isolation, and then you figure out what the state interest is that might go up against that. And so there is this very delineated step 1, step 2 in equal protection. But when we're talking about fundamental rights, the right itself in step 1 came into the Constitution with certain strings attached at common law. So while I agree we don't need to talk about today's state interest when we're figuring out what the scope of the right is, we do have to talk about the historical state interest recognized at common law. So I do want to push back on this notion that we can't talk about state interests when we're defining the scope of the right. I think we have to. Like, that's what the common law does.
If you accept that the common law is the only source of fundamental rights, but it's not. I think we all accept it's at least part of history.
It, right?
History is the guidepost. History in tradition is the guidepost, not necessarily the common law. For instance, if there is no common law with respect to a certain practice, it might nonetheless, the absence of evidence in the common law, plus some other sort of the general practice of citizens might be enough to push you over the line. And so I don't accept that looking at the common law is the only or exclusive method of determining fundamental rights.
So when you say history and tradition, you don't mean exclusively legal history and tradition. You're saying like contemporary practice as well?
That's relevant, yeah. Why would you exclude that?
Yeah, I agree with that as well.
Okay. Okay.
And also Alito cites that as well. Alito cites
I mean,
in his opinion, so it seems like
Alito does
okay
this completely wrong. He ignores quickening and all of the common law treatises just as much as Roe does. So I think
you can't say Alito ignores quickening. Alito talks about quickening. Alito discounts quickening. Ultimately, says the distinction is abandoned. He talks about quickening.
That's fair. Yeah, that's true.
All right.
So building out the case, I think
it's
a simplification, and there are other times where yes, the state interest is going to in the First Amendment context, for instance. A lot of these sui generis rules, these unique rules about the First Amendment, which don't map on perfectly to strict scrutiny analysis, they're going to be like that. They're going to be a little, where you're considering the state interest in the process of defining the scope of the right. But in general, as a simplification matter, I think it's totally fine to say, look to the right, then look to the state interest. That's typically what our practice is with these fundamental rights. That's kind of like, Barbary teaching you, preparing for the bar kind of analysis. So that's kind of how we look at it. And you might be able to later down the line distinguish abortion from contraception based on the state's interest. That's fine. But first, we're going to establish, in my opinion, the scope of the right. And so Destiny asked me, build out your case. Well, I think the decision about whether to bear or beget a child is a fundamental right because for years, it's implicit in what it is to be an American, to be a free individual, to be able to govern your family and decide for yourself what your family is going to be, who you are going to be. That intimate decision about having a child is one of the most personal things that you can think about. And for years, the cases have followed along from that. You have cases involving the education of your children, being able to teach them whatever language you want to teach them. There are cases, as we already talked about, the sterilization cases, the contraception case in Griswold and Eisenstadt. These are all following a pattern that recognizes that the essence of your liberty and what it means to be free surely must mean to be able to build your family the way you want to see it. The perfect example is like everyone points to the China one-child policy as an example of people who are not free, as the antithesis to what freedom is and what it entails. And so that decision is, if anything is fundamental, that decision must be. And it seems like Nick Rekieta is fine with Griswold and fine with contraception. Why doesn't Roe follow on from that?
I also want to add that even if you look at it real quick from a right to privacy standpoint, when you look at how we have a right to privacy in terms of your religious beliefs and where you can practice your belief in your own home, in the First Amendment, you have a right to not quarter soldiers in your own home, which is a right to privacy in your own home. There's a privacy right in your person and possessions in the search and seizure law in the Fourth Amendment, right? So there's this concept of right to privacy that has been enumerated. And then when you add that in with the Ninth Amendment, which says that while the Constitution does have enumerated laws, there are other laws that might not be enumerated that you still have as fundamental rights. You can see that there is a general right to privacy that you have. And my argument is that in Roe and Casey, they were just delineating another right to privacy, which is you can think of it as Pisco does as a right to bear and beget a child. You can think of it as right to bodily autonomy, which they say in Casey. There's a million different ways you can look at it, but these are things that Americans have had this entire time since the 14th Amendment, right? So I think that it's clear that there is some sort of fundamental right here, and there is parts of the Constitution that you can see shows you evidence that there is some sort of right to privacy bigger than what is delineated in each of the single amendments.
All right. So, Nick, fundamental difference. Yeah, go.
Yeah, fundamental difference between contraception and abortion. I mean, I hate to be rude, but are you serious? Like, one involves an actual life existing at some level. Like, I don't think any of us are retarded enough to say that there is not life, right? Like I'm not debating against that. You're saying there's not life.
Well,
I think, let me ask this. Hold on. I'm curious. Right. So it seems like the issue, and I'm trying to separate this hardcore. This is why I got my lawyer dudes in here and not normal people. Okay. Whether or not a fetus is life or not, I think my question is hold on, is there a serious position on this panel that a fetus is not life at some, like, well, I think the position is like, does the federal government or the Supreme Court have a position on that?
Is there like moral consideration is the real, and the position, life is a useless term in this.
The position has been from the Supreme Court, at least a stated goal of agnosticism towards that fact. And what's more is the cases that like seem the most relevant about whether for constitutional purposes you are a human being at conception, there's explicit holdings against that, because if you're a human being at conception, you're a rights holder under the Constitution.
If you're a person, not a human. If you're a person, right? So would you say there's a difference between human life and person? Well, if
there is, that's only an ad hoc explanation to explain why we don't have to worry about a fetus being a rights bearer. Because if a fetus is a rights bearer, they're entitled to due process under the law. They're entitled to equal protection under the law. And presumably you could see a challenge from a fetus that the murder laws are being applied differently as relates to their personhood and regular people. And in that sense, you would constitutionalize no abortions as an equal protection matter or as a due process matter. And so it's really...
Nick, do you agree with that? Do you think that fetuses are persons or should be considered persons? They aren't now, obviously, but...
I'm not positive. So we're getting into a legal argument about what is life, and I'm asking the panel if they actually believe that a fetus is not life, just in general.
There's no correct answer
as the
to that.
fact of the matter.
There's no correct answer to that.
Unfortunately, if you want to get into the weeds, I do not want to get into the weeds on the life argument because I don't see it as relevant.
Why?
But if you
Like,
want to get
why would that be a controversial question if a fetus is life or not? I mean, in any
I'm gonna
other
throw you a
context,
bunch of hypotheticals and you're
Well,
gonna
make it- yeah, hold on.
flounder.
Making
but your
these categories
hypotheticals are
doesn't do
retarded,
anything.
so that's pointless. In any other circumstance, if you took what is a fetus and you put it anywhere else in the planet other than in a womb, it would be considered life 100% of the time. So how do you delineate that? It might not be life.
Is a fertilized egg a human being?
Well,
I
he's
didn't
asking
ask if
about
it was a
life, to
human
be fair.
being.
Okay, I think. Hold on, wait. Let's.
Yeah,
So
categories only
wait.
serve a
Hold on.
purpose,
Whoa,
which is
hey,
not
whoa,
the
hey.
purpose
I'm the
why we do it.
goddamn moderator. Okay, Jesus Christ. Okay, we should be able to answer this question. I think that everybody here. I think a lot of people are trying to jump ahead to preempt future arguments, but I think everybody here would acknowledge that a fetus is almost certainly some type of life. Maybe not a legal person, maybe not a human being, but some type of living thing. I think we can all agree with that, right?
Correct.
Okay.
But the question isn't that
was
an
the only
uninteresting
question I
question.
asked.
Sure.
That's trying to bypass and get to the end, which is, does this thing deserve rights? And that's really the question. Is
Sure, but if we're not
Deserve
willing
is a
to-
separate
right.
question.
Sure.
Does it have?
Sure,
Does
but
it have
Deserve
rights?
is totally different.
For my purposes, Jesse, I'm using them equivalently. Do you, under the Constitution, do fetuses have rights? And for the
Yeah.
longest time, not even Roe, not any of these cases have been doing any kind of analysis or balancing with respect to the potential life. Not even Alito does that. Alito, in his opinion, does not balance.
Wait, so
the
here's a
interest
question
of the fetus.
that Pisco, you asked it quickly, I think, but so something, Nick. So here's something that I'm curious. So it sounds like you're saying that, like, if we consider a fetus to be some sort of life that states can have an interest in, I don't understand. How do you ever think that the Supreme Court can leave that decision up to the states? If you truly believe that to be the case, don't you think the Supreme Court should outlaw abortion the same way that it would outlaw, like the Supreme Court never say you have a right to terminate your 1-year-old or 2-year-old child. Why would the Supreme Court be agnostic on this and let the states decide rather than taking a more firm position and just outlawing abortion altogether or saying that it's unconstitutional to do it? Or do you think they should do that maybe? Yeah.
Does the Supreme Court have a constitutional prohibition on murder?
Is that like for
It would be
deprive
an
of
equal
life,
protection
liberty?
argument.
Yeah, like a 14th Amendment life, liberty.
It would be an equal
it's-
protection argument because
An equal protection argument.
If you're a
No,
rights
but
bearer,
is there a constitutional, is there enshrined somewhere a constitutional right to how do I fucking word this? I'm trying to figure it out.
is there a constitutional requirement for states to pass murder laws?
Yeah, there you go.
Yeah, if Louisiana abolished their murder law, okay, that's the hypothetical then.
I'm
don't-
asking.
No, that's the question. Yeah, you guys have to answer.
I don't think that there's a constitutional requirement for you to have murder laws, but if fetuses are persons under the Constitution, there's an equal protection argument in that there's no rational. What would be the reason for distinguishing the rights of a person in the womb and with respect to the murder laws and the rights of the person of born individuals? And if you're going to say, well, it's just inconvenient to have the murder laws apply to the fetuses, well, then you're just saying that, personhoods, and you're just saying the persons in the womb get less rights than persons outside of the womb, and that's all the abortion people are saying too. And so you're back at square one.
Pisco, I think
that's
you
not
made a
my
concession.
argument
Well,
at all. But
let Nick respond. Go.
just very briefly, no. Actually, age is not a protected status in the 14th Amendment. Age is not a protected status in the Civil Rights Act. We allow age discrimination all over the place: voting, smoking, drinking. There would be no particular obvious Supreme Court issue with having age-based restrictions, even if that's gestational age-based restrictions on murder. So again, like we're jumping ahead and acting like
You really think
this
that,
is
Nick? I mean, do you think that it would be
do I
constitutional?
really
If
do I
said
really
the
think
mur-
that? Euthanasia proponents certainly think that, right? Like that.
Well,
we
I'm not
could-
asking about euthanasia
but
proponents. I'm
it's a
asking,
relevant question because it would be an age-based discrimination on murder.
I can't speak for them. My question for you would be, do you think it's constitutional if a state says it's legal to murder someone over 60?
That is a common argument that euthanasia would be allowable
you
at
think?
a certain age. Sure. Yeah.
Okay, I think that would be unconstitutional.
Okay,
You
wait,
think
hold
it'd
on,
be
wait.
So wait, you think euthanasia would be completely unconstitutional at the federal level?
No, what he said, which was allowing murder after the age of 60.
Well, but
not-
hold on,
not
wait, just curious, because now hold on, wait,
consensual.
we're not immoral. This is legal. You can't pull equal protections for age, can you? Like if somebody can you?
It's a lower.
It's just not as suspect.
It's not a suspect
I'm
class.
so not a legal mind, but like I know that like if you're trying to sell a house to somebody, I can't say like I can't discriminate on like familial status, on sex, on stuff. But I'm pretty sure you can on age. That's not a protected.
Distinguish the federal law. A lot of those protections come from federal statutes, which prevent this kind of discrimination because they're not. It's first of all dealing with private discrimination. Of course, the Equal Protection Clause applies to government action.
How can you get? So here's a question because intuitively I think I agree with Nick, but I guess I'll ask you. You can explain this. How do we even have an age of majority if it's not okay to discriminate on?
It is okay to discriminate. It is okay to discriminate against in certain respects in age. Age is absolutely you. Nick and Jesse are correct. That is not a suspect classification. I want to say it again. I'm not saying that age is a suspect classification, but the test for rational basis is there a legitimate state interest, and is it rationally related to that legitimate state interest? What would be this would fail rational basis review? This would be one of the times that it would fail rational basis review.
Well, wait,
what kind of legitimate interest would it be?
Isn't the rational basis explanation essentially done on viability? Isn't that the rational basis?
I'm not seeing the connection between that and the hypothetical age law.
I don't see how it would be rational basis in the first place because the lowest discrimination basis that we have would not be rational basis. It would be the next one up, intermediate scrutiny, which would be based on gender. I'm not aware of any equal protection questions that fall down to rational basis. It would be at least intermediate.
There's tons of them.
All of them. Eisenstadt, for example, which Eisenstadt was the case when they first tried to apply. Yeah, they first tried to apply contraception outside of the marital context. So this was like the step after Griswold. That case originally says, look, this law is making a classification between married people can use contraceptives, but unmarried people can't. Marriage is not a suspect classification, so we're going to apply rational basis. So they basically said there's no rational basis to prohibit unmarried people from having contraception versus contraception for married. You totally use rational basis in.
There is rational basis for where it fails. There's a bunch of cases known as rational that people have labeled rational basis with bite, rational basis with teeth, and I would argue that even though this is the lowest level of scrutiny, remember for the audience, for their sake, for suspect classifications, you're going to have strict scrutiny. That's the highest level of governmental interest needing to be shown and a narrow fit. If it's a quasi-suspect class like sex, it's going to be intermediate scrutiny. That's what Nick referred to. And for non-suspect classifications, it's rational basis. That's the lowest threshold. We're going to give a lot of deference to the government. But even at that low threshold with age, what would be the legitimate purpose to discriminate in terms of age within over 60 for murder laws?
For specifically murder, which you're going to have a hard time finding a state interest in wanting to murder people.
Yeah, hold on. Can we stop using the term murder though, because that already is defined at.
Yeah, we should just say killing.
Killing.
Yeah, we should say.
No, say homicide if you want, but why wouldn't we make it
more appropriate?
Philosophically, murder is literally defined as like the unjust or unprovoked killing. So,
but we're not talking about any factual circumstance where we are begging the question about something.
No, I know, but it's like saying like should the state
law
be allowed to murder people in the case of execution? Well, we wouldn't consider that murder. Like it's taught a lot.
No. You're misunderstanding.
Murder is a legal definition, and the state would necessarily be removing it from the definition of murder if it made it
right. But we've got a fundamental issue here. We're talking about laws being restrictive, right? Like that's how we get to rational basis tests. Can someone do something to someone else? Or can someone be prevented from doing something? So murder, right, is a rational basis test. Does the government have an interest in preventing murder? When they pass the statute, that's when the test is applied. But that isn't the question here. The question is a state required to pass a statute?
In the first instance, I would say no.
That's a completely different analysis.
The constitutional problem is not having a murder statute. The constitutional problem is equal protection and failing to give equal protection under the law.
Well, let's say, okay, I'm curious for Pisco. Let's say that they were to pass a law saying you can murder anybody, or they would remove all the murder laws. Would that be okay?
Yeah, it would be okay, in my opinion.
Okay. So
you think that would be constitutional? That wouldn't violate the liberty interest. You think that would be constitutional?
It's private action, isn't it? It's private. Does the government protect against private action? I'm sorry, does the Constitution? There are some areas.
I see what you're saying. So you're not talking about the act of. I was saying that the act of removing all the homicide laws would violate someone's liberty interest. That's state action.
The courts get to decide that. That
Courts always decide. Yeah, every time when states repeal or pass a law, they're both state action.
Okay, I mean, I guess you guys are okay with reading a lot of stuff in the Constitution, which I guess we already agreed on.
But you surely you agree that repealing a law can also be violative of the Constitution. Like if someone repealed,
yeah, I agree with that.
Yeah,
honestly, I do agree with that. But
yeah,
well, but the question would be, if you were to repeal all murder laws, what part of the Constitution?
Murder laws.
What part of the Constitution would be violated?
Yeah, what are you violating at that point?
I would say the due process right to life, but I think that's state action endorsing death.
Okay.
We don't really think of other fundamental rights that way, where it's protections.
They're not saying go out and murder people if they're repealing the murder laws. They're just saying we're not going to
punish you
for murdering, which I think is very different.
Yeah. This is kind of a digression. It's just meant to show you that there's a lot of complications in establishing personhood as a constitutional matter for fetuses, and that's one of the reasons why the court has not done it, and in fact has done the opposite. I think as a matter of constitutional law, you are a person, or at least you are a citizen, when you're born.
Yes, and that's in the 14th Amendment. They specifically delineate the time that you become a citizen is at birth. They could have said you were a citizen 8 months into pregnancy, but they chose not to, and that's because the state interest there is at the actual birth child.
I think that's an abstraction, though, because citizenship is irrelevant to this question. Persons are protected by the 14th Amendment.
But no area of constitution. If you're talking about like a total aberration in constitutional doctrine, I can't think of a single case where the court is considering as a constitutional matter. I know there are laws where there's intensifiers for killing someone who's pregnant. I agree with that. As a constitutional matter where the Supreme Court has held that it's weighing the state interest of the unborn child. They're weighing the state's interest in potential life. But
I want to be super clear. I'm not saying that the fetus is a person. I think it would be abjectly incorrect to say the fetus is a person.
So you cannot distinguish.
You cannot look at the fetus's rights. They don't have any.
I would submit that you cannot distinguish.
I mean, the fetus does have rights. I mean, they have since the 1400s. Fetuses have had rights.
No, states have had interests. States have had interests in fetuses.
That's incorrect. That's incorrect. If you if you have a fetus in a womb, right? Mm-hmm. If you have a fetus in a womb and the parent both parents die, right? So you have fetuses in the womb, both parents die, and they're able to posthumously remove the fetus and keep it alive. It has a succession interest in all property as if it were a born child, and it had that right from the time it was conceived.
When is the interest vest though? Isn't it once
at the time of conception?
Can I ask a question? Can I ask a question to test that? Would it ever be? Because here's what I would be interested in. Has there ever been a case where you have a fetus that's 4 or 5 months along, and then the mother starts doing drugs or something to damage the fetus? Does the state have, or does the fetus have the right? Are there like criminal charges against the mother?
Yes. There's tort cases where the child brings a case based on the action done by the mother while they were in the womb. I believe there are criminal laws that prevent individuals and actually can charge you with a crime for endangering the life of the unborn child.
There absolutely are. But to be clear, that's different than the fetus having a right. Correct. Like a state can let me drive on the road. That doesn't mean I have the right to drive on the road. Just because the state lets a post-born fetus, a baby, sue after they're born does not mean that they would have had the right to sue.
Well, you can also look at when they are allowed to sue. It is once they are a birthed child. They can't sue while in the womb.
Yeah, presumably.
Well, a state presumably could let them if they want.
Well, so then here's a question. We're getting into the crazy
distinctions without a difference, because just because the federal government doesn't recognize a particular right doesn't mean the right doesn't exist. States are allowed to recognize rights that go beyond the federal government's recognition of rights. The federal government the Constitution is just the minimum bar.
So when there's states that have different views of what this right that you're saying is, this right to the fetus having a personhood with rights, when those states come in conflict, then how
who wins is a matter of U.S. constitutional law.
Yeah, like how do you not make it a federal problem at that point? Like, why would states get to choose that?
Conflicts among the states don't matter. It's only if it's a conflict with the federal government.
But we're analyzing the United States Constitution.
Yes.
We're analyzing with respect to the U.S. federal Constitution, and there could be, as I think rightly said by Jesse, there could be privileged or even rights extended by state governments. But the question is, as a matter of U.S. constitutional law, is it proper for the court to consider and weigh the rights of not the state and the potential life, which is what Roe says and what Casey says, but the interest of the fetus itself, which it never has done. As a
And
matter
to be
of
clear, the
US
Alito opinion doesn't go that far either. The Alito opinion
doesn't do
even
that
get
either.
close to it. Yeah.
But again, I all the hand waving aside, I presented you a place where the fetus has rights. The fetus has had property rights since the 1400s, and you can say, well, they don't get to vest those rights until they're born. No, that's not true. They have the rights. The rights are vested. They can't take possession because it's physically impossible for them to do so until they are outside of the womb. There's no way to give a baby something that is inside a womb that is physical and outside of it, but the right exists and is fully vested from the moment of conception going back to the 1400s. We don't get to hand wave that away and say, well, but they don't have that right because it's inconvenient for the argument. Fetuses do have rights. It's not a potential life. It's not a future interest. It's a present interest. And it's been there forever.
Abortion is unconstitutional, isn't it?
Wait, actually, wait. Can I want to ask one testing? I want to ask one testing question for Nick there because I'm kind of curious of that. Okay, hypothetically, I don't know how inheritances would work, but like, let's say that you have a brother who's second in line to inherit everything, and then you've got a child who is first in line to inherit everything. Using the fetal example that you just gave, let's say that you and your wife are killed in a car accident. Wife is pregnant. There is a 6-month-old fetus. Now you're saying that fetus in and of itself has the right to that inheritance, but it seems like other people in here are saying, well, that right only crystallizes once it's become a birthed person. So once it's like surviving on its own or whatever. So let's say that they get into the car accident. The fetus is taken out of the mother. Maybe it survives for like a week or two, but then it dies. Does the death of that fetus, does he now have an estate that inherited everything from the father and mother, or does the brother of the father, who is second in line, does he get it? Like, did the fetus actually inherit anything there, or did his inability to crystallize as a person make it so that he's not even considered one, and then the property goes to the brother of the husband?
We're gonna go deep into my property law memory here, but
Sure.
it's
These are like Robert had.
Well, because my feeling intuitively, I would agree that it seems like he probably needs to be a birth person before he actually gets an inheritance. So that's what I feel. But yeah, go ahead.
Most states have dealt with this issue, and this isn't just a fetal issue. This is an issue with succession in general and inheritance. But they consider contemporaneous death to be within like a 30 or 90 day window of time. So if this applies in husband and wife deaths all the time, because if a husband passes away and the wife passes away within 30 days, it's considered contemporaneous or simultaneous death. And so then the estate doesn't pass from the husband to the wife. It passes then instead straight to the children. And that doesn't mean that the wife didn't have an estate or have a present interest in the rights at the time that she was still living. It just means that it makes things a lot cleaner for the states to go ahead and bypass that based on a timeline, because probate takes a really long time as is, and passing it from person to person to person gets really, really complicated.
Sure, and I can understand that.
For everybody's
wait, hold
benefit?
on real quick. This is a very interesting hypothetical for me. So I'm going to ask one more. This is an out there question, okay? But like, let's say that I had some family members that I really fucking hated. I really don't want my brother to get some shit, or I've got a sister or whatever, but I don't have the heart to tell him, okay? Because I'm a pussy. I'm non-confrontational. Like, could I theoretically do like some in vitro fertilization where I have an egg somewhere, and then me and my wife die, but I've got a trigger to go implant that into somebody else, and now that fetus is like inheriting the property rights, like just by virtue of being like a fetus living thing? That, because that's just a hard concept for me to wrap my head around. Like, has there ever been a fetus within a state before, ever? Like, say it was past the 90-day limit of when the two people died, so you don't have it all like wrapped into one like event. Like, the concept of a fetus, you're essentially saying that a fetus can have an estate. There could be like the estate of a dead fetus, right?
Theoretically, sure.
Okay, interesting. Okay, so I got it.
I think that you get into really wishy-washy territories when you think of this concept of, well, you can have a property interest, and technically I could have my hypothetical grandchildren can have a potential interest in my estate, even though they're far removed from being born right now. Right? If I write my will that says I want to leave my estate to my grandchildren, that is completely fine under property laws. But that doesn't mean that my hypothetical grandchildren, who aren't even conceived yet, would have some interest or some rights that the United States Constitution has given them.
Well, but he's saying that right exists in conception, right?
The Constitution doesn't give rights, but the moment they're conceived, they would acquire that interest. That's where it goes from a future interest to a present interest.
Well, let's talk about the constitutional implications of what this means. This presumably means that a law that recognizes the right to abortion in any state, or indeed the federal government, that would be unconstitutional. If unborn fetuses are rights holders, the states that pass affirmative rights to abortion, those laws would be unconstitutional because you're denying due process of law with respect to the right to life. There.
No, you're not denying due process of law. They can have a due process. They can absolutely have a.
You're allowed to
process
just kill people for no reason?
Would it be for no reason?
Yeah,
If the states can create all sorts of structures that don't mean that you go to court, right? Like, for example, just this is way out there, but it's meaningful. We have a due process built into drone striking American citizens on foreign soil. Right? Like Obama did this, drone strikes an American citizen on foreign soil. He didn't get court. He didn't get, he didn't have his Miranda rights read to him before the drone missile hit him. We allow due process to exist when the state has created a process that is considered due. That's
so Nick,
basically.
Do you believe that due process is purely just following the right procedures then? Do you think there is a substantive aspect?
It literally is. Now, whether those procedures are sufficient, of course, remains a question for the court. But once the court has determined them to be sufficient, then following the process is the due process right. And it's written into the term. It is a process that is due, whatever that process may be.
With respect, Nick, you cannot, for a born person in the United States who hasn't committed a crime, you cannot just, no matter how many procedures you give them, you can't send them a notice to be like, this is your notice of termination, we're going to kill you. You're going to be able to come to court, but you don't really have a substantive claim. We just, you can raise issues about whether or not you're the right person. You can raise issues about whether or not you're given the proper procedure, but we're just giving you a notice that your due date for death is in 3 years. That's not allowed in the United States. And you would agree, wouldn't you, that that would be a deprivation of liberty under the 14th Amendment, wouldn't you?
Again,
for a born person.
I'll turn your question back on you. Where is that in the Constitution?
He just.
I would say
he's saying would be okay.
I agree that I would say that's totally unconstitutional as a violation of your 14th Amendment right, or Fifth Amendment with respect to the federal government, to life, your substantive right to life.
So you think that the government could not come up with some sort of process by which you could go, and a court could determine that they could put an expiration date on you, like that? I think
that would be totally unconstitutional. Yeah, with an expiration. Do you think an expiration date not based in any criminal punishment would be constitutional?
Wait, hold on. Just so that I understand what's being said. Are you guys talking about an expiration date that would be carried out by the state or through private action?
By the state.
Okay.
The government comes and says everyone dies at age 60, and no one gets to live past age 60. Is that?
And it goes through both houses of your state Congress. They sign it. Governor signs it. Due process, and is that allowed?
If no one gets to live past age 60, that becomes a really interesting question, doesn't it?
I saw this movie called Midsummer where people jump off of.
Do you think that's constitutional?
Do I? God, I fucking hope not.
but why?
Why?
Yeah.
Well, we're not doing moral arguments here, right?
No, legal. I'm doing legal.
Yeah. You hope it's not constitutional. That's purely legal.
Well, no, that's not a purely legal question. I hope lots of things are not constitutional that may actually be constitutional on moral principles.
I understand that moral, and I'm not letting moral dictate where I'm going.
Like I said, it becomes a really interesting question if it applies to everybody, doesn't it?
Yeah, it's interesting, but what is the answer?
I don't know. Do you?
I think it's unconstitutional, and I'm willing to say
so.
Yeah, but where? From where? Where does the unconstitutionality come from? The
14th Amendment has a substantive component, and part of that liberty is the government not killing you without a reason.
Where?
Well, but couldn't they theoretically?
That's not in the 14th Amendment.
Couldn't they?
Yeah, sure it is. It's in the same place that your right to be free from government intrusion with respect to all the implied rights that you agree with, Nick. You agree with implied rights. So we started this conversation.
Wait, hold on. Wait, okay, hold on. Interesting hypothetical. And I'm curious, right? Could this, since you said that this is just age, right? This isn't like it's not like a strict basis or whatever, right?
So
It's
yeah,
not
let's say
under strict scrutiny, right? Because it's not.
there's no equal protection.
Yeah. So then let's say it literally was like the state interest was we spend a whole bunch of money on shit like Medicare. If we kill people over the age of 60, like now we have an interest because of the administration of these programs or whatever. Could you theoretically, would that be constitutional?
If there was no fundamental right, that would be sufficient, right? But if there's a fundamental right, it's a higher level. It's a strict scrutiny analysis, and that's what we're talking about here. In the context of no fundamental right, Destiny would be absolutely right. Rational basis, we spend a lot of resources on 80-year-old people. So that's a legitimate, aim of government is to lower expenses. This is absolutely rationally related to that goal. It fits rational basis, but in order to strike it down, you'd have to think that there is a fundamental right that's separate and apart from the procedures. And I want an answer to that question.
I can foresee a dystopian future in which certainly no, but I mean, we laugh, but who knows? Like, I'm not a big climate change person, as people could probably infer, but let's say that climate change becomes some catastrophic thing, and there's a general consensus that at a certain point, humans become more wasteful and damaging to everybody around them than at a prior point. So we say, okay, 60 years old, I don't know, they take too many medications and they start farting too much. Methane is a big problem, and we've got to stop it. We can't stop the cattle, so we got to stop the people. So therefore, we come up with some reason in which the government has not only a rational basis test, but they could potentially pass strict scrutiny. I'm not positive that so long as the application of it was completely equal, that it's unconstitutional as a legal matter.
Would it be strict scrutiny or would it be rational basis? That's the question. I agree.
Even if it's strict scrutiny, there's possibility that the government can actually meet that burden.
Not now.
But it couldn't now.
No, what he's saying hypothetically, like let's say we could prove every scientist knew that like it will cause catastrophic climate change. So you have like a narrowly tailored law to a compelling government interest
If you have Destiny, if at age 60 everyone turns into a 28 days later zombie, and we know that, or at least like 95% of people do, then yeah, you would have a compelling purpose, and the most narrow means to do it is to have an expiration date. If those facts don't present themselves, then you need another compelling purpose, and I would argue that right now we don't, fit the bill for that. And so my question is, isn't the test this higher threshold and not the rationally related test, not the rational basis test?
Yeah, but the threshold, the question that you presented was, if the government had sent out a letter that said, at 60 years old, you all die, is that constitutional? The question, the answer is it can be, right?
Well,
like we all just agreed that it can be.
Anything can be, right? So anything can be. The First Amendment, even the most strongest protection on viewpoint discrimination, it can be constitutional in the right circumstances to apply it in the context of racial discrimination. I'm not going to bring up the affirmative action cases because I know you probably disagree with them, but Korematsu, at least, right, in that case, that racial discrimination was overcome by the quote unquote compelling purpose of national security. Of course, we disagree with it now, but we all acknowledge that all of these rights are not absolute, I hope. But the question is, what test do you apply? Not whether or not the government in any given instance will be able to meet the test, but do you apply the higher test, the strict scrutiny test, or do you apply the rational basis test? And that question, as of now, has gone unanswered.
Well, I guess it would be rational basis, or it would be strict scrutiny, right? Like if you're going to infringe upon life, I think we would go with strict scrutiny. And again, God, I hope so. Like I don't want to live in the country where the government puts an expiration date on anybody.
Or if the government,
if we all agree that the government can pass a strict scrutiny, which I think we all do, right, and it can do so properly, then I think that pretty much resolves this whole line of questioning, though, right? So we're saying it doesn't matter if the right to life is fundamental. In this hypothetical, we're saying that it was overcome.
It does matter, because acknowledging that there's a fundamental, substantive right to life, that's going to affect your disposition on a whole lot of other things. And the way I'm applying it is in the context of if there is a substantive right to life, and if fetuses are rights bearers, which is what
I think the second question is the only thing that matters to this discussion.
If fetuses are rights bearers, and if we agree there's a substantive right to life, a fundamental right, then surely any state legislation that allows for, gives an affirmative right to abortion, that would be unconstitutional as a deprivation of liberty, of life.
No, only if the state law doesn't pass scrutiny, right?
But why? Why would it?
That's true always, though.
Why would it
Right.
pass scrutiny?
But
I think
that being true is a critical question.
Well, no, I
isn't
think
it?
Pisco is trying to say that if literally tomorrow or like the opinion overruling Roe v. Wade gets published, and all these states now put in laws that are effectively, pro-abortion on sides that are like states that want to give women that right.
What does
then
a pro-abortion law look
would-
like?
Everyone has a fundamental right look at what they're trying to pass in Congress. Everyone has a fundamental right to abortion, and any interest, any state regulation or any whatever.
But this is the problem, right? Because absent the law, you have access to abortion. There's not a law creating abortion. So again, we're at this weird place where we're arguing on one side of it, but a state doesn't pass a law to permit abortion. A state must pass a law to restrict abortion.
Yeah, but
Why are states considering
didn't you
passing laws
just say
now?
that? Didn't you just say that, like in your opening statements, that you think that this concept of whether or not abortion should be allowed should be kicked back to the states? So wouldn't a
Yes.
state that wants the ability for a woman to choose to have an abortion have to put in a law that would say that they are allowed to do that?
No, he's saying the
You have
default
to have
position is
a-
it's allowed. Everything's allowed by default.
Yeah.
Wait,
Do you
but-
have to have a
let's say
state
that-
law to allow you to buy ice, like to allow the sale of ice cream?
You would it
Probably
would
in
still make sense
California.
to pass- It would still make sense to pass a state
Touche.
law. It would still make sense to pass a state law because municipalities or other local towns might disagree with you, and they might pass restrictions on abortion. And the state says, okay, we don't want to allow any of these restrictions that exist in municipalities, and so we're going to give people an affirmative right here. And so in that case, it makes total eminent sense to have a state law that enshrines a right to an abortion. And my question is that constitutional if indeed fetuses are rights bearers? And I think unless you have strict scrutiny, you don't meet that burden. And if you're saying that you have strict scrutiny, that kind of undermines, I think, your argument on distinguishing this right from contraception. Because if you're saying you're passing strict scrutiny, what you're saying is essentially there's a really good reason to abort fetuses. And that would undermine the notion that this is like fundamentally different than contraception. It's making
it's
fetuses closer to contraception. And so if you answer
The
right now
idea
that
that-
passes strict scrutiny, you're in trouble.
the idea that contraception and abortion are the same things is absolutely absurd to me, because one involves an actual thing and one involves the potential that a thing might exist at some point. And specifically preventing the creation of that thing, which then becomes a right holder. Wherever you find that thing to become a right holder, it doesn't really matter. But contraception prevents the creation of it necessarily. And unless you consider like RU 486 or, as to be something, because that allows, contraception but prevents implantation or whatever. Those are different questions that I think we need a lot of, that we get into moral discussions on when a life is a life. And I'm not quite sure at that very early stage if there's a practical test that would be meaningful to allow for it. But that gets beyond the scope. Contraception and abortion are clearly different, because one involves something that is, and the other one involves trying to prevent something from being.
Okay.
Can I ask
you agree,
Pisco and
you agree with
Lego-
Griswold? I just want to. I'll answer your question, but Nick, you agree with Griswold? It was rightly decided.
Do people have a right to contraception?
Yeah.
Yeah, I'm fine with that.
Okay.
Can I ask Pisco and Lego, from quickening to viability, what is the history and tradition that protects? Like, it would seem that history and tradition are really cutting against it at that point for sure.
The essence of your
So what
question
is
is
there?
why. The essence of your question is why is this viability line not arbitrary and the height of
Yeah.
arbitrariness, right?
Yeah.
That's the essence of your question.
What in history and tradition can we staple on?
My answer to that question is every fundamental right has limits, as we just acknowledged, all of us. And the limits imposed by the courts in other cases of fundamental rights, they're rooted in prudence. They're prudential. They're policy. Look at Brandenburg, for
Well, they're
instance.
primarily rooted in history and tradition, and then there is a prudential act.
The line
But-
is prudential, right? So I agree with you that the fact that there's an incitement law, the fact there's an exception to the First Amendment, the fact
Yeah.
that there's an exception there, that is what's based in tradition. But the line of
Where do we put
Brandenburg,
it?
where you
Yeah.
apply that, It's prudential,
Can I-
right? It's we don't want to chill speech, and so we draw the line at a place that makes policy and prudential sense all the time. It's not an aberration to have a line. Viability makes eminent sense. It's a place where it's based on objective facts, and facts that are knowable. It's weighing the interest of the woman to have some time to be put on notice for when that abortion is going to come. And so, in the same way that Brandenburg is, I guess cosmically arbitrary, I guess viability is cosmically arbitrary, but it makes prudential sense.
But what if history gives us a more crystallized line?
Yeah,
why would we go for?
I just want to
Sorry,
ask
go
a
ahead,
quick
Dustin.
question, and you guys tell me if this is a dumb question, okay? So I have a big problem with you're talking about the history argument. I have a big problem with the history argument because I feel like if it were the case that tomorrow we discovered in some library, in some congressional hall or whatever, there was a book and we flipped to those pages and that book clearly said, common law in the 1700s stated that no woman shall ever do anything to interfere with the life of a fetus. I don't know if I would believe that people on either side would change their mind. I feel like I don't know if I'm believing 100% the historical argument, because I feel like people start to draw from other amendments instead rather than looking at common law at the time, or vice versa. If I find a common law, somebody says we find a book and it's like women can actually destroy or terminate their pregnancies even post quickening or whatever. Like with the other side, instantly changes like, oh well, look, like there's a basis for abortions in the past, I guess for Nick then, right? And then so I guess we should be able to have them now because when the constitutional amendments and everything were enshrined, we seem to be
The reason that we think of common law, the whole definitional purpose of it is it's like what was the generally understood default, and then everyone could deviate from the default if they wanted to. But so the reason that the book hypothetical doesn't really work is because we do have a historical record. That's the whole point of the American and English law system, is that there is this concept that there is a commonly understood baseline, and then we just have to build off of that baseline. And all I was getting at with the viability versus quickening idea is if there is a commonly understood baseline that seems to be more rooted in history and tradition, why would we take maybe it's prudential, but why would we take a prudential line when we have just as prudent a line that has a better basis in tradition? That's what I'm so lost on.
I don't think it's just as prudent. Prudent.
Okay.
I think really quickening, what does that mean, right? First of all, sources disagree, as Alito's opinion mentions, that sources disagree on what the definition of quickening is in the first instance. And what I understand it to be is related to fetal movement. But surely there are, that seems like if you're going to complain that viability is this weird thing where it could, move backwards in time, which by the way is not an aberration. States' interests move all the time whenever we're doing these kinds of rights analysis. But surely there is just as much uncertainty about when your baby starts to move. There's variation there as well. And so I'm not so sure that it's just as
but Heller and McDaniel both so these are the guns right cases, the cases that said that there's an individual
McDaniel
right
or
to
McDonald?
firearms.
Is it McDonald?
Mix something. Whatever the right answer is the one I'm going to go with. But those refer to treatises that existed at the time of colonial America that say, hey, this stopping tyranny thing is part of the justification for this right to have this individual firearm. Obviously, today, that's laughably dumb that we could fight the U.S. military with our individual pistols. Well, maybe some people disagree with that, but I think that's laughable. But I don't think just because the change in circumstance has happened, I don't think that should justify moving where our lines of justification for our rights come from. I think that quickening is very stupid by modern standards, and if they had pregnancy tests like we do today, back in the 14, 15, 1600s, they probably would never have talked about quickening. But the fact of the matter is, at the common law, that's what they did. So just like it's stupid to say we have a right to guns to stop
your
the
example
US
is
Army.
bad, and I'm glad that Rekieta is sighing, because I think the fact that there's a militia component in that sort of precatory clause, that doesn't define the scope of the right, so says Scalia. And so no part of the militia clause is defining the scope of the individual right with respect to guns, even though that is one of the interests that was grounding the Second Amendment. I think Nick would agree that that's not operating on the individual rights component. The individual rights component is serving that end among other ends.
Well, let me briefly just say, if we're talking about respecting rights and anything. Every like implied right question goes out the fucking window the moment we bring up the Second Amendment, which is the most disrespected enumerated right that exists. Like we're talking about, and this is one of the fundamental problems I have with Roe versus Wade, is that it enshrines an implied right that they pulled out of, again, some hybridization of the 9th, 4th, and 14th Amendments. It enshrines it as far more protected and far more protectable than enumerated rights that we have, specifically the Second Amendment. But briefly, just the idea that we can't possibly, in a modern time, fight off our very cool, super awesome government with
I wish I'd never brought up guns.
Rifles. But like the idea that we can't is belied by every single either guerrilla resistance country or insurrectionist country that we've encountered that has made America look like a fucking laughingstock for the past 20 years. Afghanistan, Iraq, now we've got Ukraine making Russia look a little bit silly, and we're not talking about equal applications of force. It's just insurrection and militia tactics versus a government have worked forever, and they go both sides of the aisle down throughout history. So I would just disagree with that statement entirely, and I think it was entirely proper to include the militia analysis in Heller and McDonald.
Can I wait? I kind of want to ask a question. It seems like this is a really bad segue, but you brought up guns, so now I'm interested. The Second Amendment seems to be quite enumerated, in that Congress shall make no laws abridging our right to bear, or whatever. I forget the language, but like it's relatively clear. How is it that we can simultaneously take like Roe v. Wade and Casey v. Planned Parenthood and perform like a bunch of like legal alchemy to like construct this highly implied right to protect so much abortion power throughout all the states? But then when we look at the Second Amendment, like I don't even remember what I was allowed to own in California. Like you can't have like pistol grips on rifles. You can't have certain magazine sizes. I don't even know if you could buy pistols in California. Why are we so okay being so restricted on something that's so much more enumerated than like the highly implied right of abortion?
Not to bolster Nick's point, but it doesn't even get strict scrutiny, firearms. Just so
we don't know yet, right? There hasn't been. Heller didn't decide
they haven't
that.
applied it yet.
Heller didn't decide that, and we have to wait and see what the scope of the right actually is. But the reason why we're spending so much time now talking about what the Second Amendment means and what the limits are is because, unlike Roe, the Second Amendment as embracing an individual right, that's a relatively recent opinion. I'm not saying that the Second Amendment is like less valid than implied rights, but we really started to think about, Heller was a sea change. Heller was a significant opinion, and we haven't had time to really deal with it, especially given the fact that, as we know it, as originally intended, the Second Amendment didn't apply to state governments, and that's where all the gun laws are. And so the Second Amendment was thought of before incorporation. I remember McDonald is in 2010, I believe, I think it's 2010.
Wait, but doesn't incorporation change all of that? Like, don't you fight state regulations on firearms using the Constitution?
It was just incorporated in 2010. And so you haven't had time to breathe and to have an analysis of how the states are going to handle this. And so, of course, you're going to see disparate opinions about what the standards are. And also, what does the right to bear arms mean? The Second Amendment says the right to bear arms shall not be infringed. Just like the viability line, which we were talking about before, we're going to have to draw some hard lines that are going to be based on like prudential factors. Like, are nukes included? Probably no one here thinks nukes are included.
I do.
Okay.
100%.
Okay.
100%. Warships are included. Cannons are included. Everything was included at the time of its passage. The fact that we've changed, there's an easy way to fix that. It's another amendment.
Okay.
Well, I agree with that. Yeah. I think the way to fix all this is a constitutional amendment, but that's like
tasers?
That's
what
like
about tasers?
Statement, right?
Are tasers arms?
Are tasers arms? Yeah, sure.
Wait, historically, were you allowed to own like cannonball launching machines and shit back in the 1700s?
You still are. Cannons aren't firearms that are regulated by the NFA. The explosive shells are. So you could buy a cannon right now pretty much anywhere. That being said, yes, the warships of the Revolutionary War and the Civil War, the cannons were borrowed from private owners. Yeah. Like not to get too deep into the weeds on this, because it's a completely different discussion and one that would probably be much more fun than this one. But Pisco, you brought up an interesting point that it's only been adopted in 2010. It was actually adopted, it applied to the states in Heller, I think, in 2008, but that's splitting hairs. Either way,
that was DC. That was the DC ordinance.
Yeah, that was
oh yeah,
federal
I guess
government.
yeah. So that's okay. Yeah, correct. So McDonald applies it in 2010, but the only reason is because the Supreme Court has been so fucking afraid to take a realistic gun case since U.S. v. Miller, which is an absolute joke of a case in and of itself and how that played out. But like,
aren't they taking one this term?
yeah, New York State Pistol and Rifle Association, which again it's like they have. The Supreme Court and Clarence Thomas has commented on it that it's a secondhand right in the eyes of the court. The one they ended up taking has so little potential to make meaningful change in Second Amendment jurisprudence, and it's because they really didn't take much laws. But that also has to do with states not really restricting things for a very long time, whereas in all of these other areas we have state tests on those constitutional rights much sooner.
Well,
So
Texas is one of the first states to pass gun laws in the 18.
I wanted to get back at on the abortion.
Yeah, I was gonna
topic.
say let's send it
Yeah,
back.
I was gonna say,
because
do
we
you want to talk about
gotta
stare decisis maybe? Like,
Hold on. I just wanted
wild.
to make a point real quick on the fact that the Second Amendment is more strictly regulated, or I think that's what you were trying to get at, Nick. And I think that's only to a certain degree, because it's not that like abortion is just okay in current times. Like there are still restrictions on it that states can put on, and states have.
Well, wait,
So there
isn't that
are
only laid
regulations.
out past? Was it Casey that laid out the different trimesters? Like I thought before.
That
Well,
was
no.
Roe.
So Roe had a trimester framework, and then Casey slightly changed it to be this-
Overruled is the correct word.
Why did you say that?
Overruled is
We had
100%
a
the correct
plan.
word, and you know it.
We had a plan.
Casey definitely overruled Roe,
I
and
misspoke.
it
I
100% overruled the 8 other abortion cases between
No,
them.
I
Stare
misspoke.
decisis being respected in Casey is a joke.
Okay, so then the question is, so like,
change
don't you
it to
basically
provide
have unimpeded access to abortion in a lot of states, depending on the time? Like, if I could go out and literally have an abortion every other month, biology willing, if it was like a second or if it was like a second month abortion, or whatever, right? Like,
in DC, you can do it up until the moment of birth.
How is that not unconstitutional under your eyes, Nick?
I think he
Whether
thinks
or
it
not,
is. Yeah.
I think it's wrong. Whether or not like and I think it highlights the problems with the arguments for abortion. But again, I think it's up to the states to decide whether or not they should allow it. But that's the thing. But real quick, to answer your question about the Second Amendment and how whether the test of restrictions, right? Because you said you can get abortions, you can get certain guns, but the interesting thing is if you were to apply the requirements to acquire a gun to an abortion, everybody would say it's wrong. Right? Like if you said, well, I mean, if you wanted to get an abortion, you have to get permission from your sheriff to.
I thought we did
to
apply
get one.
undue burden to guns. I thought
Yeah,
that's
we
what the
do. We
statutes
just
do. So it's
we just
exactly the
apply
same.
it. We apply. No, it's not the same though. Like, because if you have to go and get permission to purchase a gun from many states, right? You have to get permission even to buy one. So you say, okay, I want to go buy a pistol tomorrow. You've got to go to your sheriff and you've got to apply for a permit to purchase or a permit to
You're
carry.
saying the standards are the same; they're just being applied disparately
Yeah,
when it comes to
right,
guns. I understand the point
as-
you're making.
Yeah.
But that could make sense. I mean, that could make sense depending on the interest. The spousal notification at issue in Casey, they gave reasons why it was the case that kind of notification was overly burdensome. But
So
maybe
talking
there's
about
different.
Casey then, though, so
Let's
spousal
do
notification
spouse
versus
stuff.
24-hour waiting period.
Yeah. What about
What? So in Casey
wait, hold on,
itself,
wait, fuck.
the majority couldn't.
I really want to
Sorry,
poke
yeah.
Pisco on that last thing.
Yeah.
What, like, for such a clearly enumerated right, what is the rationale
Yeah.
for why I need to go and do my fingerprints and sign up for whatever to get a gun permit?
The reason why I think it would make sense to have bans on the kind of notification requirement under Casey in the Pennsylvania law, where it might not make sense to ban those kinds of notification systems or prior approval. I mean, to think about this, Pennsylvania, it's not prior approval of the spouse, it's just notification. What Nick's talking about is much more burdensome. It's not just, I'm going to notify the sheriff that I'm going to get a gun. It's, I need his permission to get a gun. I think Hawaii has something like this as well. And so I'm not denying that it is much more burdensome than even the Pennsylvania statute at issue, which was struck down as being too burdensome on the abortion right, where it was just notification. Don't deny that at all. But what's different, I think, are the competing state interests. In the case of guns, you have a legitimate state interest and concern that people who, if you don't, now you can dispute these facts. And I'm sure Nick would. I'm sure many gun advocates would say, this is not saving anybody. It's just making it more burdensome for legal, safe gun owners, that criminals aren't going to follow laws anyway. But, states are allowed to make mistakes.
I understand. Like, so here's a question. I legitimately don't know the answer to this. Can you buy a car without a license? Or do you need a license to buy a car? What?
That's state law.
Yeah, but like I'm asking, like, can you buy a car without a license at all?
Buy a car, I think you can.
Yeah, so I don't know. That just seems kind of strange to me that it's like more burdensome to buy a firearm that is like a clearly enumerated right in the Constitution versus a fucking car that a 4,000-pound weapon that I could drive through a school, right? Like,
but if they did, right, that's a matter of policy. That's a matter of policy. Would you think it's unconstitutional for the state to pass a law that makes it more burdensome to get a vehicle than to get a gun? I don't think it would be unconstitutional.
Well, no, but because having a car, I don't think is like a
so that's a policy disagreement, just like the bestiality policy disagreement that we talked about before. You can have a policy disagreement with respect to, you should say, like, vehicles should be the same as guns, or vehicles should be more than guns. That's fine. The question is, if they passed a restriction on vehicles that was like the gun thing, would that be constitutional? And is the gun thing constitutional? And they're just comparing the two as a matter of policies isn't going to get you to the constitutional question.
Sure. I think the interesting constitutional thing, though, was just that, like, again, like, there's a lot of work we have to go to build out abortion rights. And we seem to be we have a huge interest in making this as less burdensome as possible. That anybody should be able to get any abortion for any reason they want up to certain levels or whatever. Or I guess whatever they want, period. But when it comes to firearms,
viability.
Yeah.
No, most of the laws in Casey were upheld. The 24-hour waiting period. There
was only one that was struck.
I mean, like, but a state could theoretically pass a law allowing you to do any abortion up to any point, right? Like, that's where we're at right now.
It could if it wanted.
Yeah. So, but for firearms that are strictly enumerated, right? Like, I can't attach a barrel to a thing. Like, all of my barrels have to be a certain length. I can't have certain grips and certain guns.
The state interest is different, Des.
And the problem with that too is the federal government has laws on firearms. The federal government doesn't have laws on abortion, so
yeah, it does.
complicates
the
the question a lot.
The Hyde Amendment and all the funding abortion cases.
About whether it's restricted or not is what I'm saying. Though, like, a state couldn't say anyone can buy a gun without.
You're wrong about that too. There's limitations on the type of there's partial birth abortion ban in the federal government.
Well, and then also I don't think
we're talking about the right itself. A state could say anyone can have an abortion at any time. A state could not say anyone can buy any gun that they want.
Destiny is talking about restrictions, not outright bans. He's referencing restrictions, not bans. And so the comparison would be an outright ban on pistols, and we know that's unconstitutional from.
Sure. I'm just because Nick's point was that, like, if we were to take the burdensomeness that states are allowed to enact against firearms purchases, which is a strictly enumerated right, and throw that into abortion, people would lose their minds. It would be like we would see that as a horrible thing, right?
Yeah, let's put all the women who want to get an abortion. Let's have to get the permission from the sheriff and put them on a list. That'd be good. Let's do that. Let's see how that flies.
That's just not even close to being a good comparison, because sometimes there's like medical necessity where if you had to wait that long, the mother could die. So like that just doesn't even make sense.
Almost never. I mean, it's almost
all
never.
these laws have exceptions for the life of the mother.
No, I know the medical necessity of abortion it's almost never. It's so rare that it's laughable.
Well, and then also, to be fair, if we were to apply the same test to a firearms person, if somebody were to go and it's like, I can't do this 2-week waiting period, like, I feel like my life is in danger now, I need to buy a firearm. I don't even know if you can do that, right? Like, there's going to be like pretty strict limits in place.
Guys, the interest, the key component, the key difference is the interest analysis. With respect to like owning a bazooka or like owning a nuke, the potential interest of the state in safety is way, way, way higher, I would believe, and now you can disagree with me, than the interest in potential life at any state, even in the early stages of pregnancy, which is what we're talking about, not necessarily viability. We're just talking about restrictions that might carry forward in the first, trimester, first set of weeks. And so I think that the interest analysis is what distinguishes those two. And what's more, to put your fears aside, we actually don't know what the standards are for the Second Amendment yet, because it's been so recent that we don't know what the standard is. And so maybe it'll come out that it's actually way more protective. And so I think it's a little bit premature to say this is some aberration. And
okay.
Also, I would argue that just because something is enumerated doesn't mean it gets more protection.
I mean,
I would say the substantive right.
I would 100% agree with that. I don't think there should be any difference. It just is what our foundational principle is going to be.
But you're, first of all, like I think you're sugarcoating the reality of where the Second Amendment is to overturn like state reasonableness restrictions on guns would have to go back and overturn U.S. v. Miller, because again, the federal government is allowed to have a level of restriction on guns that many states emulate. Well, all states emulate because it's a federal restriction, but like, so the idea, well, we just don't know how they'll treat it with the states. I mean, U.S. v. Miller is a huge infringement.
And to be fair, the Supreme Court can do all sorts of things that should be overruling things and don't. Casey,
you guys don't mind overruling cases, right? And you guys don't mind that.
As long
clearly
as
no, of course not. Of course not.
Okay.
I'm perfectly happy with.
You?
I'm perfectly happy with no, wait, come on. Like what? We don't want to overturn Plessy versus Ferguson because it was stare decisis. Oh well, of course we do. So I guess it has no weight to you. Come on.
The question is on what grounds?
And so different.
And I would tell you that the stare decisis principles for Roe v. Wade and Casey are so strong, and the ones that are comparable in Plessy are relatively weak. And same thing with Wagner, same thing with all these other cases. Yeah,
well, I think a really important aspect of that, though, is that Casey. So do we agree or disagree? I think from the very beginning, there is a certain set of stare decisis factors, which just for chat purposes, these are like when do we decide to overrule and when do we decide not to overrule? In Planned Parenthood v. Casey, the court plurality, not majority. Which means that not 5 justices, just 4 justices, but more than anyone else, said that for certain types of cases, really controversial cases, the stare decisis factors...
That's a majority. That's the majority. That's the opinion of the court. That's like section 3 of the analysis.
Not everyone... No. 4 justices joined the stare decisis watershed section.
That's the court. That's the court. That's the majority opinion. That's 5 justices.
On the stare decisis, watershed is higher scrutiny?
Yes.
Okay, either way, the point that I'm making is, are we taking the watershed rule from Casey? Do we think that that's a principled rule that's rooted in history? Or are we taking just the traditional stare decisis?
Absolutely. It makes total sense to having a functioning judiciary that enacts the judicial power of the United States under Article 3. Absolutely. Can you imagine what would our courts mean if people really believed that they were merely bending to the whims of political change? The whole structure of the Constitution
was a watershed.
You think people don't believe that now?
But wait. The people do believe it now, but to have it in this dramatic and aberrant fashion, to be totally where we have senators from various states who are telling you the reason we're bringing up these new abortion laws is because we have our guys are on the court. That is such it's a crisis of confidence in the court. And
I think Texas and Louisiana are 100% at fault for creating that. I don't think that's the court's fault, but I honestly agree.
It's not just like that. It's
testing it because of new justices is
well, no,
bad.
hold on, no.
If
the court chooses to go against stare decisis, the court has a responsibility there as well, but not just the states, right?
It has a responsibility to explain its decision making and for us to apply stare decisis factors. And absolutely, there should be a higher threshold for these kinds of watershed cases. And absolutely, Roe v. Wade is one of them. And that's a majority opinion of the court.
Yeah, what makes it a watershed
cases? So Roe v. Wade is the basis of a lot of substantive due process law, and so it's the foundation of so many other follow-on and companion cases. It's the fact that it's been affirmed numerous times, the fact that it's has incredible media and social and cultural attention and huge division among the people. That's the kind of thing that the majority opinion in Casey recognized were things that indicated watershed cases. Another one is Brown v. Board. I don't know if you guys think that was wrongly decided. I assume that since you're citing Plessy as a case that should have been overruled, I assume you think that Brown is also a watershed case, or maybe you just reject
agreeing
this kind of dichotomy.
That a case is a watershed does not mean that you agree that a watershed case gets different stare decisis treatment, though. So I would
But
totally
that's what
agree.
the court implies in
Watershed.
that's what the court implies in Casey.
Yeah.
Well,
I-
Casey's
yeah,
about to get
I'm conceding
overturned
that.
anyway, so
But
too
that's
bad.
the thing. It's do we accept Casey is the whole point of this conversation.
It's getting overturned because originalists think is that if the original ruling is not based in originalism, then it's not.
Then it's
There's
egregiously
no
wrong.
justification. So then, of course, any originalist judge is going to look at any case, even if it is a watershed case, and say, well, the founding or the justification for this ruling is not grounded in originalist thought, so therefore I can overrule.
Well, hold
it.
on. To be fair, can't you disagree with the ruling whether you're an originalist or breathing Constitution
Yes,
person?
yes,
like
yes.
you don't necessarily have to be an originalist to think it was a bad ruling. You
He's
could also
recognizing a pattern.
He's
of
just saying
people.
Alito is, I think,
and Thomas
Sure.
and Thomas
and all these guys.
who's
I don't
always
think
concurring
it's
and
not
saying I'm going to
even just-
overrule it.
It's not even just the actual like justices who think this. This is ingrained within the Federalist Society, who has said this before, even on like their YouTube videos that are open to the public to watch to see what they're about. You can look at different like legal foundations who've posted things. I mean, one of the times they I think when Bork got nominated to the Supreme Court, they had a huge expose in their like in a newspaper that said we now have the opportunity to roll back 30 years of social and political activism. This is something that has been going on since the 80s when originalism kind of transformed into this new conservative outlook in judicial theory, where they kind of went away from original intent and went towards original meaning. And you can see this since then that this is what was inevitably going to happen if there was ever a originalist or conservative majority on the court. They're just going to attack laws that they think that to them
Well,
do not
I
have
think
the same justification.
I think that you're right, like a little reductive, but I think you're doing that on purpose. Like it's not a problem, and it's clear that even when O'Connor was put on the court and we got Casey, the whole point of us having Casey was because there was a push to overturn Roe, and O'Connor was the holdout. So I agree with that, but I do think that there's more to it. There's more to it, even in this opinion. We might say that it's not very well developed, but they're not saying it's wrong, therefore overturned. They still talk about workability. They talk about reliance, and I think they do a really bad job. I think reliance is like the worst section of this. Either that or the historical analysis are just so weak. But like they do agree. I think everyone agrees that just being wrong isn't enough. Like I think that's disingenuous to say.
Alito doesn't agree with that. And you can tell
Alito, I think Alito really does think it's not workable.
Hold on. Do you think that's enough, Nick? Does stare decisis mean anything to you, or do you think if it's wrong it should be overturned, or do you think this one is so egregiously wrong that it should be? Yeah.
If stare decisis should mean something to everybody, but if a decision was wrongly made, I think we should all agree that if it was wrong then it's wrong. Like, I don't think it should be given some sort of weight.
Then what does stare decisis do?
It doesn't mean anything then.
If it's wrong and you overturn it, then that's not stare decisis. That's just we overturn wrong cases.
We overturn wrong cases.
There's no reason
why wouldn't we overturn wrong cases?
Because of stare decisis.
Well, but then what about when we brought up earlier other cases where...
Well, if something is wrong, if it's fundamentally incorrect, like we could go back to great things like fucking Wickard versus Filburn, and we could say, okay, here we have FDR implementing a policy and pushing the courts to make decisions that are counterthetical to the Constitution for his particular policy of management of this financial issue, right? So we know that FDR did that. We know FDR pushed forward cases. So why do we honor the case just because of stare decisis? But if we know it's wrong, it should be overturned.
Nick,
in the same way that
you're just assuming that everybody is in agreement that it's wrong. There's plenty.
Well, it doesn't matter, right?
Well, it doesn't matter. I hear you. I hear you, Lego, for sure. That one of the assumptions is that it's wrong. But let's just take it as a given that it's wrong. Sure. Nick, you might have a good case for Wickard, right? Wickard, by the way, for the chat, Wickard is a case where purely intrastate activity, Farmer Filburn, was it, or I don't know, I think it's Farmer Filburn, was growing like wheat on his own property for his own consumption, and on a theory of like aggregate commercial activity that affects interstate commerce, the Supreme Court upheld basically the government screwing with Farmer Filburn, even though it was all intrastate activity. You might have a good case for overturning Wickard because, there's been developments in the law. There's been Lopez. There's been the Affordable Care Act where they did not uphold the ACA on a Commerce Clause basis. And so you would apply the factors, but if you didn't have that like development of the law over time, it would be a much harder case to get rid of Wickard. Wouldn't you agree?
It may be, but the question of whether or not it's harder practically is separate from the question of whether or not we should uphold bad decisions that are bad. Right? Like if you have a wrong decision, the stare decisis shouldn't be a magical thing that says, well, we have this wrong decision, but I guess we're going to stick with it because of stare decisis. That's my whole point here is if a decision was wrongly decided, then it should be overturned. We shouldn't need some extra justification because, like, imagine handcuffing yourself to say, well, I made the wrong decision. I could change it now. And we could set things right. We could set things to the appropriate place. But God damn, I just made the wrong one earlier. It's nonsense. No one lives like that.
I think to bridge all of this, like all of us agree that stare decisis is important. But just because you
no, we don't agree.
I don't think Nick does.
No. Hold on, wait, stop. Yes, he does. Okay.
No,
right?
he doesn't.
I'm pretty sure what he's saying is it's one factor. But like you consider other things. Okay, wait, hold on. Let me ask directly. Yeah. Nick, do you think that like precedents? Do you think stare decisis anything? It should ever be weighed in whatsoever at all? Or do you think it's okay? Yes.
No. That's not what you asked.
Does it just mean right or wrong?
What?
Destiny. That's not what you ask. What you ask is, would you ever uphold a wrong decision, a constitutionally wrong decision, on stare decisis grounds?
And of course not.
Okay. So what does stare decisis do other than just being first impression? Yeah. What's the difference between a first impression case?
Well, I mean, the difference would be, I guess, a weighting of whether or not it is correct, right? Because the decision was made, so somebody at some point justified it in some way. But again, whether or not it is correct is the ultimate question.
Okay, wait, hold on, wait. Okay, I 180. Sorry. So then, Nick, it sounds like you don't care about stare decisis at all. You basically you only care about the merits of the case. Because when we say the word like, is it constitutionally correct? Like, unless I could be a dumb fuck, aren't all matters brought before the Supreme Court weighed against the Constitution? That's like what the Supreme Court evaluates, right? So you're saying there's never a case where maybe even a little bit of a constitutionally incorrect case is allowed to persist with a new court due to stare decisis. You would never agree with that. You say no, they should always be overturned, right?
Again, if it's constitutionally incorrect, it should not exist as a American law.
When Alito talks about workability and reliance, you think he's just wasting his time? Like he doesn't need to do this. Why would bother? Right?
Yes. Again,
that's principled position. I just don't agree with it, but I do think principled.
Yeah.
Well, then here's
principled positions can be very difficult. I know.
Well, here's a question that I have for Nick. Well, because now this seems like, in my opinion, that knows nothing. Now it seems like we've completely undermined the courts, though, right? It seems like every presidential election cycle, every single 5-4 decision now becomes like the new feasting ground for our next judicial pick. And every single time we've flipped the balance of the courts, every state is going to be trying to... I don't think it's bad to try to artificially... There's a name for it. We artificially throw a case to the court to try to get a ruling. I don't think that's necessarily bad. But when every single new court majority is seen as an opportunity to overrule a whole bunch of old cases, doesn't that kind of undermine the validity of the Supreme Court?
No.
Okay. I think it does.
It absolutely does not, because the Supreme Court is a product of politics. First of all, we could really go back, and I can make all of the other three lawyers on this panel scream internally by just mentioning that Marbury versus Madison was probably wrongly decided, and watch them all die right now, see them dying in real time. And but
even if I agree with you, though, I think that stare decisis, that God is going to kick in to save that one.
I don't.
So what I hear is that Nick wants to get rid of judicial review. Okay.
That's not what I decided.
If it was,
how is that not what you said, Nick?
We have an 8-1 majority conservative court, and they decide to get rid of all of their power, and now everybody is right with the world.
How could they even decide that? How could they review whether or not Marbury versus Madison's right?
That's the problem with Marbury versus Madison, is how you would even come close to unraveling it would be it's impossible, right?
Well, but that's stare decisis, is it not? Isn't that kind of what we're talking about?
Yeah. It would be unworkable, which is one of the stare decisis factors. But so you at least think correct and workability.
I would do it if I could.
Okay, Jesus. Okay.
Oh yeah. Wouldn't you? Wouldn't you?
You would overturn everything. You would overturn everything.
Literally.
Right?
Yeah.
Oh God, what would we do? How would we live?
That's a good question. I think that it would be very miserable for a long time.
It would depend on what state you're in. We would have 50 very different U.S. states, I think we would. Yeah.
Oh, God, it's almost like that's what they wanted in the first place.
Judicial review is not just all the things that the court does. The court does more than just so to give a break to Nick, the court is not just striking down laws or applying the Constitution to new fact pattern. They're interpreting and doing other stuff as well, and applying facts to law.
But who's going to decide what the judicial power of the United States under Article 3 means?
This guy right here. I got you.
Well, you say that they do more, but they only do more because they interpret Article 3 to let them do more.
Yeah, so it's a hard thing to undo.
Article 3 has very specific duties of the court, of the Supreme Court. Like that. They're absolutely written down. They're written in Article 3.
Hold on, I'm curious. If I were to go and look up, because I don't know what the fuck Article 3 says, but if I look it up, is it going to be using like vague words that are going to be up to interpretation that everybody's going to fight over?
The judicial power of the United States is
it's some jurisdiction. It's going to give you a list of things that is part of the federal judiciary power. And then Section 2 of Article 3 is going to talk about the original jurisdiction of the Supreme Court and the appellate jurisdiction, and where and what cases they're allowed to hear as an initial matter, and the exceptions clause of the appellate jurisdiction of Article 3, Section 2. And so there's it's not
all you're going to get is that they can hear cases. You're not going to get what does that mean.
Yes, and the Chief Justice, I guess, in Article 1 sits for impeachments of the president. I don't know any other thing that's, I mean, even lower federal courts, as we know, are not mandated by the Constitution. The only federal judge that's endowed with his office, with their office in the Constitution, is the Chief Justice of the United States.
There's not even a number of justices. It's almost like in theory we could have appointed thousands and thousands of them. We could have had a multi state system of Supreme Courts that would just hear individual cases similar to the appellate circuits that we have now. We could have had a completely different
system. I think a panel Supreme Court would be great, and I think we still can. Like that's not forbidden by the Constitution.
No, none of it is.
A panel where you don't know who your justice is would be great.
It's not forbidden by the Constitution, but you know who it is for what basically undermined the possibility of doing that was Marbury versus Madison. And then the Judiciary Act. Yes, it is. And then the Judiciary Act, which went ahead
which was the first Congress. When the first Congress passed the Judiciary Act. And so you're saying that what they're doing is unconstitutional, or it wasn't in the framing of the Constitution. It's like people like Madison who are in the Congress who are passing it.
And they're still arguing, and those people even argued about what the Federalist Papers said, and they wrote them. So for the record, we're not in new territory.
Yeah,
okay, wait, let's move off or you can finish your point, and then let's get off the restructuring the entire U.S. legal system.
Real quickly, though, imagine the difference if there is no precedental decision, but instead we have a Supreme Court grand enough to hear all appellate cases, and they did it on a case-by-case basis. That is the alternative, and it's certainly a workable possibility that would allow for the state petri dishes that were originally intended, where we were actually 50 sovereign. Well, we weren't 50 at the time. We were individual sovereigns united in purpose under a federal constitution, but with large state control. I mean, Reconstruction, I hinted at it earlier, and it's a long discussion too, but Reconstruction undid the original meaning of so much of the Constitution, and whether or not
it amended the Constitution. The Constitution is not static.
That one. Yeah.
The Constitution is not static. It was never intended to be. It was supposed to be a union that lasted. And to respond to your point about, why don't we have a Supreme Court system that's disentangled and separate? The whole point of having a Supreme Court system was to settle controversies, of interpreting state laws between sister states, which are deemed, competent to hear federal questions. And so the whole idea of federal supremacy of law and having one Supreme Court was to have a final arbiter. And I think you're undermining the structure and purpose of the Constitution by proposing whatever system that you're suggesting.
No, I fundamentally disagree, because those having one court doesn't mean having one literal courthouse.
That's true, but that's not forbidden by the Constitution as it exists right now. You could pass a law that made a panel that rotated the Supreme Court. I don't think that would be unconstitutional. With the circuits.
Yeah. But we won't, because of Marbury versus Madison. We don't need to.
Destiny wants us to move on to...
we should move on.
Okay, actually, there's a lot of funny... I have a lot of questions, but okay, so I'm going to roll this all back to what I think was one, even before the start decisis thing. I think there was kind of like one fundamental question that I think kind of figures out what side you're on. You guys were kind of talking about it a little bit, but I didn't hear us like drill into it. And then Nick, I know you mentioned you have to leave at some point. If we have to take off, that's fine.
About 25 minutes.
Yeah, that's fine. No. That's not enough time, you fucking piece of shit. No, that's fine. That works. Okay. So you guys were talking about like when a fetus becomes like a rights holder or a person. I feel like this is actually probably the most important thing that got discussed, and there was kind of like flying by, and then you kind of moved around to other topics. But it seems that like Nick has this idea that you become a rights holder essentially at the moment of conception, or as close to it as we can measure. But you guys, the other three of you, or I don't want to group all of you, but seem to say that you become a rights holder as laid out in what, Casey, or as laid out in whatever state laws post, whatever. Like, how do you figure that out? Yeah, talk about that. Yeah, go.
So go ahead, Lego, if you want to go.
Yeah, I was just gonna say, I think that the concept of viability makes a lot of sense, because when you look at something like a unborn child, and you think about it in terms of like, should there eventually be any rights given to this thing? Well, when you look at viability, it means that that thing can live outside of the mother's womb, right? So
Sure.
I think
I want to. Okay, so I'm just gonna
Do you
drill on
think
this.
fetal rights?
Well, I'm
kick in
gonna drill on
viability?
this for like 1 minute. So I'm gonna go past the unsatisfying idea that like that's gonna be a continually changing thing, right? Viability is gonna come early depending on technology.
That's state's interest, though. That's state's interest, not rights holding. Just to be clear, the viability line, that's state's
No, we're talking
interest.
about our own perceptions, though. Like Lego could think that viability.
Even in that hypothetical, like let's say that there's a hypothetical where the instant that that a woman conceives a child, there is now this hypothetical technology that we have that can immediately transport that fetus, or the fertilized egg, into some incubator and take care of the child. I think that it would be a completely different world when we're looking at if we could outlaw abortion or not, because at that point, I think anybody who would be in favor of abortion would be fine just snapping the baby into the incubator, because to them that is the abortion.
What if it could be transferred to a willing surrogate?
Terminating their pregnancy immediately at the time that they want. You know what I mean? So like viability can still be this fine answer, and with evolving technology.
With respect to Lego, the question, I think it's a different question. I think you're answering the state interest and the scope of the right question. What Destiny is asking is a totally new thing that Casey and Roe did not address, which is not looking at the state's interest, not looking at the fundamental right of the pregnant person, but looking at the fetus as rights holder and where the lines are around that. And the answer, why don't we give rights to fertilized eggs and conception, is, I think the realist answer is, it'd be super inconvenient to do so. And it doesn't make it would be so impractical, so unworkable. Think about what that means. If you're a rights holder at conception, that means that every fertilized egg that's been frozen is a rights holder. They're all entitled to equal protection of the law. They're all entitled to the due process of law. It makes sense to have rights attached at birth.
Well,
we can pick you up, we can count you, we can move you places, we can see that you're there, you're identifiable in, with a visual inspection. And so it might be unsatisfying as a constitutional matter, but as just like a pragmatic prudential matter, it makes sense to have all these rights attached at birth. And there's constitutional support for that, given the citizenship clause, I think, of the 14th Amendment, that what the framers intended were to have at least the majority of your rights attached at birth.
Okay.
Yeah, so I just want to be clear. I don't think that a fetus is a person for constitutional purposes, but I don't think just because if you argued that the fetus was endowed with some right, doesn't mean they have to be endowed with all right. So I think I want to push back on the idea that they would be entitled to full equal protection under the law. Children don't have as many rights as their parents.
Sure, we're
So
okay
I
with that,
don't
but we're
see
saying
why-
we're establishing some baseline of rights. Like one of the most basic, I guess I couldn't say is right to not be killed or murdered or whatever, right? But like some sort of baseline of where there's like an interest for the state to say, we can, limit other
Allowing
people's.
them to be born.
Sure.
The problem with all of this is that it's arbitrary, right? Like it's no matter what standard they've picked, it's arbitrary. So birth is arbitrary because gestational age is irrespective of birth. A baby born at 27 weeks right now is about as likely to live as a baby born at 36 because we're super awesome with our cool medical technology. So what does birth actually mean? Like what is this? If we go back to the quickening,
that's arbitrary too.
Yeah,
Isn't
well,
conception arbitrary?
I haven't argued for conception as
Okay,
the
sorry.
thing. And it may be splitting hairs because of the way, but I honestly think implantation is the better measure. One, because it eliminates the conception argument you made about all fertilized eggs suddenly have rights. Also, there are tons of conceived babies that do not implant and will never grow for whatever reason. So I think implantation is actually the most objective standard as to when we have a human life, or if you want to call it a potential life because you pretend DNA doesn't exist, that's fine. But the reality is that is a solid, perfect place to say, once implantation has occurred, we now have a thing that can be vested some level of rights. I completely agree with Jesse. Children do not have the same level of rights as parents. Rights vesting at different ages isn't all that weird. We do it all the time. We just don't think about it because it's so normal for us. But the ultimate problem with, again, birth, viability, these are flexible. They're sliding scales. The quickening is a sliding scale. The quickening, and I know Jesse is making a legal argument that it's a good place for historical purposes, but let's remember that the quickening is based on the idea of ensoulment, that a soul literally enters the body when a mother feels it move.
It's fucking stupid.
Right. Some mothers don't feel their babies move until they're born. Like, there's that whole TV show of fat women dropping babies out of them. They didn't even know they were pregnant. Like, funniest thing on the planet, by the way. But like that actually is a thing. So we have a standard place that we know that if uninterrupted by either some medical issue or outside factor, this will grow to become a human person, period. And that's implantation. It's the only non-arbitrary place in human gestation.
Wait. I gotta draw just one question, and then Pisco can do whatever he needs. So, by what you've just said, then, why should the Supreme Court not basically say abortion should be illegal? Because we've essentially said you're murdering somebody. It's kind of what
because the Supreme Court doesn't write laws. I mean, I know they do it all the time effectively through decisions, but they cannot write a law making something illegal. The states would have to write the law, or the federal government would have to write the law.
So effectively, I'm sorry, I suck at lawyering, but like, say a state tried to write that, somebody would 14th Amendment equal protections. You can't just murder like these things. Could not somebody do that to where the court has essentially outlawed all forms of abortion under like equal protections or something?
You might get there. I don't know that you would. Because again, we vest different levels of rights to different people by age all the time.
Yeah, but not being killed seems to be
the
like
right to life.
Yeah, that seems like a pretty.
But yeah, I think our basis for doing that
is the right to vote fundamental.
I think the right to life is I would say that's like even more integral. Like the bare social contract is like the state is going to defend you, and I would almost say, and at least in the case of like voting, there's like a very good, at least ostensible reason for limiting voting up to a certain age. I don't know how you get there with respect to the life argument.
So the reason I think fetuses don't have the right to life, though, is because if you look to the common law, it doesn't seem like they have the right to life, and I think that's just such an easier way to do it.
I just want to say this out, Nick, and I know you want to respond. I'm so glad you brought that up, Jesse, because notice what in all of Nick's analysis, which is like, that's a fine analysis. He gets away from my annoying hypos about fertilized egg. I mean, it's a very tactily, and like I think it makes more sense to say that that's when personhood starts in conception. But notice what you didn't see in that analysis. You didn't see a historical Alito-like analysis. You didn't see like citing common law and Blackstone and Hale. He came up with it because that's prudential, and that's what, it makes sense for him. And so I don't like this accusation that, viability with respect to states' interest is so, it's not connected to the Constitution, it's not connected to law. What you just did in defining the scope of when personhood begins is just as untethered.
Again, I would argue that it's not just as untethered because, as I've stated multiple times, we have recognized the rights of fetuses going back to the 1400s. So
can you give another example besides property rights? Because property rights are just so much more intangible than other types of rights.
I think the one that Alito mentions in his brief is that transference. The idea that if you try to murder a mother, but it accidentally, or if you try to kill a fetus and then you end up killing the mother, that there was common law transference of the intent to murder of the fetus onto the mother, which shows that it can be murdered, which I think was Alito's citing.
Yeah, I mean, recognizing the right to life of a fetus has happened all over the place. When you do look at the idea that killing a baby inside of a mother is a homicide, it is classified in the same way in many states. When you look at there are laws that state that if a mother were to intentionally harm a fetus through various means, like either overconsumption of alcohol, through some sort of intentional act, there are states and there are places before states that before the U.S. existed that also recognize that was a problem. That's
just
not
because the state
something to do.
does that doesn't mean they're obligated to do so because of a fundamental right of the fetus.
Correct.
This is just like driving a car again.
But
Yes.
And again, because a state or because a federal government did not enumerate it doesn't mean that it didn't exist, right? Like that's part of the whole point of this question, isn't it?
You're citing instances of policy from different various states. And
where do those policies come from?
Well, and Alito does the same thing, to be fair, which is why I think this is kind of an unprincipled opinion. It's like footnote 32, I think. But he goes through and he cites all these people who are talking about the common law, and they say, we accept the common law, but it should be this. We accept quickening's the law, but it ought to be this.
He cites treatises,
that are saying what things should be, but not what they are. And I think that's where he has the weakest part of his entire analysis, because he also says Parliament passed a law that protected fetuses from the very begining.
Oh my
God! Parliament doesn't matter.
We need to drill this down. You remember the questioning from Judge Jackson, where they're like all soying out about her answers to foreign law and how you would interpret that? And now Alito is citing post Declaration of Independence, post Revolutionary War, foreign law in interpreting what the Constitution means.
Everybody does this when it helps them, though. They like in the gay rights cases, we appeal to foreign law. In abortion, this case we're appealing to foreign law. Everyone does it, and when it doesn't help them, they always say it's bad.
But
it's totally hypocritical. Totally.
The premise argument here is that there's an implied right to abortion, but what I'm hearing over and over is that a fetus can't possibly have an implied right to life.
Yeah, you are.
There's no grounding in history.
There's limiting principles to
there's no grounding in history for an implied right to abortion either.
There's grounding in history for a decisional right on whether to bear or beget a child. That's
a little bit different than to terminate a pregnancy, isn't it?
I hold more fastly on the.
I know you think contraception and abortion are the same, so you'll say no because you're like, well, no, if I wear a condom, it's the same as stabbing a knife into a baby. I got it, like that, but that is nonsensical. Like you have to realize at the end of the day.
You're talking about the fact of the matter. He's talking about the law.
You're talking about facts, right? So there's. I would totally agree with you, Nick, that there are factual distinctions between contraception and post-implantation abortion. I accept it. I accept that it's different significantly for destiny as well, that these are factual distinctions. And I also recognize that legally, there are distinctions that matter in the fact that abortion, there's a higher state interest. I'm willing to say there's a higher state interest with respect to abortion than contraception. But what we're talking about is the essence of Roe and Casey, which is, does abortion follow along from the pattern of the substantive due process rights cases that we've seen before? And the answer is yes. The state's interest is different. The factual differences are certainly there, but it totally follows along on the essential holdings of the previous companion substantive due process cases. That's where the right comes from. And that's what the court's holding has been. At some point, Destiny, I want to run the stare decisis analysis because that's what changed your mind. And so I think that it's important that we address it at some point, but I'll let people respond, obviously.
I mean, just briefly, because I have to go in about 9 minutes. There is a point where factual distinctions make the law into a different question, right? Like where we go, okay, yeah, we're following along a line of cases, but the factual distinctions here suddenly mean that law, that line of law that we're following doesn't exist, which is why even though we're not talking about the fetus's rights, because Roe versus Wade and PP versus Casey, they didn't consider the fetus's rights. They only considered the mother's interest in termination versus the state's interest in bringing about or protecting a potential life, right? Like, but when we say that this is a different thing factually, suddenly we're outside of the realm. And factually, abortion is entirely distinguishable from contraception. There is a thing that might have rights, and the fact that Planned Parenthood versus Casey and Roe versus Wade decided not to wade into that question doesn't mean that question isn't there, isn't valid, and those implied rights don't exist. And you guys, you again, it's this hand-waving thing. It's like, when I mentioned that we have respected fetal right to life for a long time, that that actually has a history, you're like, well, but that's not a history that's very convenient. And so I know that's wonderful, but we don't just look at Roe in this vacuum of, well, we don't get to consider these other things because Roe didn't consider those other things. If Roe incorrectly omitted serious questions, either due to time and technology, remembering that at the time Roe versus Wade was decided, not a single one of those people had ever seen an ultrasound, which is a pretty different thing. And I can tell you, as knowing plenty of people who remember when ultrasounds came out, that it was a life changer. It's something that is so like terrifying to anti-abortion or pro-abortion activists, that the idea of showing a female an ultrasound of a baby in her womb is considered to be an undue burden in many places. So like the fact that all these things exist, and again, this goes back to the problem with the quickening, is that we have a completely different medical understanding and medical reality and scientific reality than what was happening in Roe, and then of course what was happening even back in the Middle Ages. And so again, to pretend that none of this exists because people didn't ask the same questions is silly, especially when we're talking about implied rights.
What's silly is thinking that it is even workable to have fetuses with due process rights and equal protection rights. It would be totally unworkable for our societies. I don't know. I don't think you've convinced me. You might convince some people, but you haven't convinced me that it wouldn't federally mandate that states not recognize abortion or not give protection. I'm certain that, at least from my opinion, if that were the standard, that you had due process and equal protection rights.
Just real quick on that, though. I thought you said that you thought it might be okay if the state got rid of all their murder laws. Like, why would the state have to step in and affirmatively protect the fetal life?
Because it would be just affecting one age class, right? It would be an equal
Correct.
protection issue
And
of the 14th.
if you're saying, well, there's a very, very, very good reason for affecting those people worse, what you're essentially saying
a rational basis would be it's more workable not to protect fetuses, right?
Okay,
Well, then
so
at
if
that
you're
point,
applying
don't you
rational,
basically
no,
toss
but
out your
you're
ruling?
sorry, you're not applying rational basis. Excuse me. You're applying strict scrutiny. It's a fundamental right to life. We agreed on it. Nick didn't, maybe. But at least
I
among
understand
us.
what you're saying now. Sorry,
So,
I
so it would be strict scrutiny, and given that it's strict scrutiny, you need a compelling state interest, narrowly tailored. And if you have a compelling interest that's narrowly tailored, what you're saying essentially is that there's a really, really good reason for aborting. And if you're saying there's a really, really, really good reason for aborting, you're undermining your rationale.
Yeah, I was going to say, because it sounds like if you're making this argument,
we're talking about equal protection. I thought you said not.
This would be a due process argument. This would be due process. No, if you're a fetus, if you have a right to life,
homicide laws for some ages but not others.
There's two arguments here. There's both an equal protection argument and there's a fundamental rights argument. The fundamental rights argument here would be the following: a fetus, whether it's at conception or at attachment, would have a fundamental right to life. At least I would agree with that, and I think most people agree that there's, among persons, you have fundamental right to life. That's our whole analogies about the expiration date, the 60 years, the 28 days later hypothetical. Since you have a right to life as a fetus, there needs to be a compelling state interest, narrowly tailored, for us to be able to cut off that right. And
for
if
the
you
state
say
to deprive it, but allowing abortion wouldn't be depriving it, would it?
Yes, it would. Wait, no. So allowing abortion, come on. If there was a government law,
here's a question.
Genuinely,
Could you
can you not think of a situation in which a state would have a compelling interest to allow some abortions?
I would,
because I can think
they could, but like, let's say a state made a law that said that you could only kill people that were 11 years old. Would that law be okay? Because isn't that essentially kind of what we're saying? Well, that's what they're basically doing with abortion laws.
But Nick is saying that you can find compelling reasons to kill the unborn child. I would agree. I think it's true that you could find compelling reasons to kill an unborn child. But that's undermining your argument for the actual rights analysis and distinguishing between that and contraception. And also, if you're saying it's a compelling purpose, I'm sure that would only be for the life of the mother, and I'm sure that would only be like in the cases of rape or incest. And therefore, okay, it's constitutional to allow abortion in those cases, but not in all the other cases, in which case it's a very loose right, if that's what you're talking about or that's what you're referencing.
Yeah, and again, the my favorite part of this entire discussion is that we're coming to the conclusion, and it seems to be the conclusion that you're coming to, that that abortion should be federally prohibited because there is some sort of right to.
That's your logic.
And
No.
that's the logic that you've espoused.
We do not agree that rights
Denying
attached.
personhood to fetuses. Yeah.
I deny personhood to fetuses, and so that logic would not follow.
Okay. Well,
It's interesting.
I'm trying to say if you gave rights to fetuses, this would be the outcome.
So the question would be, what would the problem with that be?
He just outlined them.
That people who are against this case are all saying that what we want is we want more democracy. We want the states to decide. But what they're using to distinguish contraception and abortion is this notion of life or personhood. That's what you use, because frankly, that's the only thing you can do to distinguish that in contraception. But once you've done that, you've put a rod on your own back, because you have to accept a whole lot of other baggage, which is the necessary conclusion of that logic.
So
I
the
think
problem
you can use history though. You don't have to use the life to be the distinguishing.
sure. Wait, hey,
right?
let Nick, he's got like 2 minutes, so go.
Yeah, sorry.
Yeah, this will be my final point. But so what you're saying though is that the problem is that people are saying we want more democracy, we want state control, but the result might be that we recognize that a fetus has a fundamental right to life, and the government has to severely limit the times in which we can kill that life, and that's a problem for you.
Yes.
It's
Yes.
not. You're going to hit me with the hypocrisy thing. What I'm acknowledging.
I'm not hitting you with the hypocrisy thing. You've been doing this the whole time. You're putting words in my mouth. Stop it, buddy. I'm arguing in good faith.
Okay.
Wait, hold on. Wait, can I summarize
answer
it? Because
would
he's got to leave. Isn't you're basically saying that, like, you guys are saying, you conservatives are saying, we want to kick it back to the states, but you're not kicking it back to the states. It seems like what you're doing will invariably lead to a banning of abortion. That's like the issue.
Correct.
Yes. Yeah.
That's my point.
I disagree that it's invariable, but if it does lead to the point where we recognize that fetuses have a fundamental right to life, what is the problem with that?
The problem is that
I know that people
you're being a hypocrite. That you don't want to leave it to the states. What you want to do is you want to constitutionalize pro-life.
Sure, but this isn't a legal argument. Now you're attacking him personally for what he might or might not believe.
But
right?
I don't actually want to constitutionally do that. Like, that's not my goal. My goal would be to leave it to the states. But if the outcome ends up being that, my goal is irrespective of what the actual outcome is, right?
Would you be against that ruling? Would you be against the ruling that the Constitution prohibits you to, as a state, to allow abortion, or at least to support it?
Or it endows fetuses with rights, I guess.
Or even let's go to the easier question. Let's say the majority of Americans, 51%, believed, Nick, what you believe in, that at the moment of attachment or whatever, that they're like now a rights holder. Doesn't that almost invariably lead us to banning all abortion?
No, I don't think so. Personally, I think the states will largely ban abortions. I think a majority of states will. I think abortion is overinflated in its popularity, and I think that Roe versus Wade is a big reason for that, and a lot of discussion about it throughout history. But that being said, if the outcome is that that fundamental right, or that a baby or a fetus is a person with fundamental rights comes out, would I be opposed to it? I'd have to read the basis on which they get there. Personally, I thought like if we're going to have abortion, fetal viability in Casey was the better rule than the quickening on the practicality standpoint, because I thought that eventually we would get to a point where fetal viability is effectively zero. But that being said, the as applied sort of logic of it didn't ever merit out. But I just find it interesting that the criticism of the outcome is based on people's potential hypocrisy rather than on the merits of the outcome.
That's one criticism, which is essentially that
that's an invalid criticism.
No, it's not, because what I'm trying to show you is that your logic is not doing what you say is one of the appeals of your logic, which is leaving it to the states. That your logic could, I think, very rationally lead to a constitutionalizing of pro-choice positions. And so that's attacking the policy argument. This is better for society and democracy. I think it's totally legitimate to bring it up.
And I would suggest that the levels or the hoops that we have to go through to get to your outcome, you laid them out as if it were a simple thing. I don't think it's anywhere near that simple or that foregone.
Okay.
Anyways, gentlemen, it's been a blast, but I do have to leave.
Good luck.
So
yeah, thank you, man.
It's a pleasure screaming at all of you.
Yeah, it's been fun.
Peace.
Bye.
Thanks.
God, what a insufferable fucking loser, right? Everybody scream at him now that he's gone.
Yeah,
that was interesting.
I think it represents like a radical position on something that not even the Alito court is willing to touch. And so, frankly, I think that.
Wait, for new viewers, I'm just kidding. It was super cool that Nick joined and chatted with us. Okay, I'm only trolling. Jesus.
A workable constitution.
The thing that I find most striking is the stare decisis piece, and people talk about that all the time. People say all the time, "I believe in stare decisis," but I think the only factor should be, is it right or wrong? And then I'm agreeing with what we were saying earlier. I don't see that stare decisis anymore. That
it's
like
not.
You're
it's
not.
not.
It's not.
It completely changes the concept of what the reason we have that doctrine. It's not.
I want to give. Go ahead. Sorry.
No.
I want to give some weapons to Destiny to fight the obnoxious comparisons in his chat to Plessy, and to the suggestion that we think that overturning cases is always wrong. It's not always wrong. The question is, apply the stare decisis factors and see whether or not the judgment in that case, one, was wrongly decided. I think we all agree that as a necessary condition to overruling the case, it has to be wrongly decided. We're not going to overturn correct decisions.
And then you got to figure out how bad it is too.
Yeah. And I think that matters too, how bad it was decided. Go ahead, sorry.
No, I was just saying, and I can give for chat, I can give you reasons that the stare decisis argument for Plessy is completely different. There was a campaign by Thurgood Marshall to actively destroy the precedent piece by piece. And it started at the Court of Appeals level with Murray versus Pearson, which was like his first case that he argued outside of law school, which was a Maryland law that said that the law school wouldn't admit black students. And the Court of Appeals ruled in favor of the black student and made segregation in terms of law schools in Maryland illegal, which then opened a path for a case called Missouri ex rel Gaines versus Canada, which the state, that was a Supreme Court case, which the state must provide legal training to every qualified person to satisfy equal protection. And that was one of the biggest deciding factors of Brown to overrule Plessy, was because there was these swath of cases underneath it that radically changed the concept of what separate but equal was, up to the point where in Brown they said that you cannot segregate schools at all. It is
and interesting thing is, what you're describing as well is exactly why Ginsburg said she didn't like Roe, because this like piecemeal type way of advocating in the court tends, at least in her opinion, it wouldn't engender as much like digging your heels in if you slowly built up to the right to abortion. But the Roe court did what it did, and now we're still dealing with it.
That's what they did, and that's what they did with the gay marriage case in Obergefell. First you had Bowers, which was overruled in Lawrence, and then you have Obergefell. Right.
I'm just saying it could have been more progressive. But I don't mean progressive like you know what I mean, like in small bits at a time.
For the audience's sake, I do want to formally say what the factors are for stare decisis. So you guys know what you have to apply when you're given the question to distinguish Plessy and Lochner and all these other cases. Number one is workability. Is it possible to use this law to apply to facts? Is it are the courts...
The original rule is what we're talking about. Is the original rule workable?
Mm-hmm. Are you able to, or is it just totally unmoored and you can't really apply it in any conceivable way? That's workability. Number two is what Lego just mentioned in distinguishing the Plessy case, legal developments that undermine the logic of that decision. I would point to one example for that is the vaccine case, Jacobson, where at that time it was kind of like a really low threshold of authorizing or accepting a vaccine mandate in that case. And I would hope that nowadays that we see a higher burden on the government to have a vaccine mandate. I'm not saying they couldn't overcome that and they couldn't eventually have a vaccine mandate by showing that, a heightened scrutiny of an important interest that's substantially related to that goal. But I think that legal developments over time can affect the core essence of that holding, whether or not you should overturn it. Number three is factual development. Have the assumptions of our cases change in a significant way such that the ruling just doesn't seem fit anymore. In Plessy, all the assumptions about separate but equal being a plausibly equal or plausibly workable had just been totally undermined by decades of Jim Crow. I'm missing one. Am I missing one, or is that all of them?
Reliance.
Reliance,
big one.
Right. Yeah, that's a big one. Has this decision engendered a reliance interest in the people, the citizens of the United States, or in discrete groups of people? And if you apply those factors to Roe, I think it's a very, very clear application. There's been no inconsistent precedent with respect to the core holdings of Roe, no legal or developments. Well, I already said that. At least with respect to the outright restriction on abortion, there's been nothing that overturns that. You can talk about.
If I could jump in just one second,
Yeah.
I want to make clear for the chat as well. The way that the court actually deals with these issues is they're only dealing with the case before them. So this court actually did not need to figure out what is the full scope of the abortion right. All they had to say is a 15-week abortion ban constitutional? Right. They did not need to do everything that they're doing here. Is a 15-week abortion ban an undue burden? So what they could have done is said the undue burden as applied in Casey is not quite right. It should be a little bit more like this. And at 15 weeks, a ban is allowed. But we're not going to go whole hog and say abortion restrictions the entire pregnancy 100% allowed. That's what Alito does in this opinion. And that's where I think he goes the most off the rails. And that's where I think if you want to attack his principles, that's where you do it. Because he did not need to decide moment of conception forward. That's not what was before the court. The only thing they had to decide was 15-week abortion ban, yes or no, and then give a rationale.
Yeah.
But sorry, I thought that was worth jumping in just because they go way off the rails on that. And I think that hurts the stare decisis piece, is that like just because Roe was wrong as applied to a 15-week abortion ban does not mean that they had to throw out everything Roe said.
Yeah, they didn't have to do that. These.
Well, maybe they won't.
Well, okay. Well, I think that they will.
Yeah,
I think that they will.
I guess I get that. For my biggest takeaway from all of this is that I feel like I haven't heard a good justification to kick this issue to the states. I feel like I've only heard.
It's a good idea to do that.
Yeah, I feel like I've only heard arguments for making it so that there are federal protections on abortion, or making it so that there are like heavy federal restrictions on abortion, like basically prohibitive. Because I guess. I mean, I can't speak to no more than Nick, obviously, but like it feels to me like if we go down the road of saying that like implanted zygotes are rights holders, it's like a hop and a skip to their life should be protected. Like that feels 100%. Intuitive to me.
To steelman him, I think that kicking it to the states, though, I think he's saying is the consequence of the correct answer, not his goal. So like we kick it to the states to decide whether or not the driving age is 16.
No, I understand, but what I'm saying is that like if we've gone so broad to say that like if we've gone so broad as to say that we're not even ruling on abortion anymore. We're in a fundamentally different area where we're saying that like implanted embryos are rights holders, then you can kick that back to the states all you want, but you're going to get 50 million court cases immediately. Like, this woman is trying to murder my fucking son. He's a rights holder, whatever, or whatever. Like, there are going to be other interested parties at that, because states are interested, right, at murders and shit, right? That all sorts of people are going to be saying, like, hold on, like, I don't understand how. Or are you going to define? Because then, because what seems even more impossible is, are you going to define rights holders that we can kill without provocation? Is that going to be a thing that?
That's why the court hasn't. This is an aberration. It's radical. The courts have never.
Like, do we allow euthanasia in this country? Is that legal, or can doctors
not
medically?
Right?
Yeah. So it can be if a state wants it to be. Probably.
But it's not a right.
But it's not a right.
Is that Glucksberg or assisted suicide?
Well, that's assisted suicide's a little. Okay. Well, it depends on if you want to mince words, but we do know there is not a fundamental right to assisted suicide. That was the Glucksberg case where a lot of these ideas come from. Mm-hmm. And Glucksberg, I think, if someone did want to argue that there were legal developments that undermined Roe, I don't think this is like the best argument, but I think they could argue that Glucksberg, looking to firmly rooted history and tradition and saying it was always a crime to suicide, to say it was a crime to abort, I think that's their best argument that there's been legal development, but I don't think it's great.
It's just like, okay, you have one case that like potentially might be, I don't even think it's inconsistent with Roe, and I don't think it's been held to be inconsistent with Roe. And also all the other cases affirming Roe, Casey, June Medical, is it Gonzalez?
I think the thing that they'd want to argue, if you want to say stare decisis demands this be overruled, and you accept stare decisis has factors other than being wrong, I think workability is the place you want to have a battle. A lot of courts have expressed that undue burden is difficult to apply. And Casey, the court couldn't even agree on which ones should be unconstitutional and which wouldn't, the different restrictions. So I think if you want to have that fight, workability is where you should have it. But I agree, the facts
You have it on the undue burden.
changed.
You have it on the undue burden standard, and you don't
On the
have
undue
it on
burden
the
standard.
Yes. Okay.
Yeah, not the core holding of Roe, though. And I think that's where all of this fails. I think that some kind of right to an abortion, it's just so hard to come up with an argument using stare decisis to get rid of it. It's
Also,
really
I don't know how
hard.
this would influence things, but like in terms of like viability, like what if I live in a city and it's like the fetus is viable 2 cities away? Like would I have to drive an hour to go there? Or what if hospitals just stopped carrying the equipment necessary to, like nurture a fetus taken out of the wombs? Like is it like that seems really complicated.
Yeah, we haven't
That's
had the
another part of the
opportunity.
workability argument. Yeah.
You could. That's kind of a harder one to say. I don't think we've had a decision where viability has been assessed at national standards versus local standards and what we would do. But like that's kind of what we do all the time with other kinds of case law. Think about the obscenity case law. There you have national standards with respect to value to determine whether something is obscenity, but you also have local standards in terms of whether or not it shocks the conscience or whatever the standard is for
And
obscenity.
there does appear to be a locality aspect to the undue burden cases, because all the time we talk about, or if you listen to oral argument, they'll talk a lot about, okay, how many miles away, if this goes into effect, how many miles away will the new abortion clinic be? If we make doctors have admitting privileges, what % of the state's women are going to have to travel overnight at this point? So we do look at it that way. But again, that's Casey's critics say, how the fuck do we apply that? If 20% of women are going to have to do 3 days travel, but 80% of women live in a metropolitan area, is that an undue burden at that point? If someone wants to say we got to get rid of Casey and the undue burden standard, that's the argument to do it. But I mean, back to what I was saying earlier, though, even if this court wants to get rid of Casey and undue burden, they didn't need to go whole hog and say rational basis from the second of conception. That's a bit too much.
I also think
Especially
it would have been interesting, not to attack Nick's position, but it would be interesting to find somebody that's like kind of more conservative in terms of courts, but I don't want to say more.
Someone
reasonable.
to defend Alito's opinion. Someone who doesn't.
Somebody
go
somebody that would defend, because Nick seemed like he didn't care about stare decisis at all. Like if there was a Watershed case from Marbury versus Madison, he would say fuck it, overturn it. So it would be interesting to hear.
Can we stop there for a second? Can we
Sure.
stop right there? Overturning Marbury versus Madison. I don't know if there's a more critical case in terms of reliance.
Yeah, it's like it would be like the legal equivalent of the United States, like or the economic equivalent of like defaulting on our debt. Like it would just be like an
It's the
inconceivable.
first case that you get taught in constitutional law in law school.
Yeah,
But he's saying the reliance interest doesn't matter. Who gives a fuck if everything in the United States relies on it? His whole point is that's all fake news. So I mean, he doesn't care.
I'm curious for like somebody that's conservative but still sees like, well, there's value in the Supreme Court, because having like, it feels like the Supreme Court is probably what we would ideally want to be our slowest institution, like more so than the executive, more so than the congressional, that if you could flip the court 5-4 every 8 years or something, and then you're getting a whole new docket of completely overturned cases, that would be like, what even is the Supreme Court at that point?
It's a disaster.
To be fair, making it the slower institution is part of the goal of making stare decisis its weakest at the Constitution, which we didn't actually really touch on much. But stare decisis is at its absolute weakest when we're talking about the Constitution, because if the Supreme Court gets a constitutional issue wrong, Congress can't just change the law.
Sure.
Like, we're stuck with it until we
Okay,
amend
but
the Constitution.
you have that one. Yeah, absolutely. I agree that it's at its weakest in the constitutional realm, but it's still strong in the constitutional sense. And it's even stronger when you take into consideration what the Casey opinion had to say about watershed cases and the perception of. I remember in oral argument, Justice Sotomayor said something like, "Can this court survive the stench of us overturning in these circumstances Roe v. Wade?" Where essentially, I'm going to say it because this is what I believe, there was court packing from the Republicans with respect to Merrick Garland's seat. And that happened in a context where the entire intent was to politicize the court and to overturn this case. And the court shouldn't be seen as a mere vehicle for political and policy objectives. Even though there's a political connection by virtue of the fact that you are nominating someone who aligns with your policy perspectives, probably, and the advice and consent process is obviously a political process as well. The court's supposed to be above the purely political, the purely policy. And this looks super bad for the legitimacy of the court in this context.
The fact that this leaked, though, makes that question even hard. Like, my favorite thing in this entire case is at the very end when Alito says, "We do not pretend to know how our system or society will respond to today's ruling before we make the ruling." And then it leaks, and you're like,
well, the big thing about the leak that I guess we're never going to talk about it. Or I would say, like, it seems like people aren't going to talk about it because they're more concerned about the ruling than the leak. But I feel like it's a pretty vital question to figure out who leaked. I think that's a really important.
I agree with that. And if it looks a little different, if the case looks a little different when it comes out, can we survive that stench? That, oh my gosh, the court saw what happened. And
well, that's the question of what the leak.
We'll never know.
Like,
that's what I'm saying. That's what's so.
Something I'm curious. If a justice actually leaked this, do you think that should be grounds for like? Because I almost think it would be because
impeachment?
Yeah, because
you need
like
60 senators, though.
You have truly politicized, like beyond a shadow of a doubt, you have truly politicized the court at that point. There is no reason for that leak to ever happen other than for political pressure to vary the ruling. And then I'm sure you guys.
I don't want to say definitively, but
sure.
but I think that I'm leaning on the side. Like if that happened, that would be such a breach of norms and also stupid and futile. And affect the legitimacy right away in a way if it were a liberal liberal justice.
Well, we don't know if it's stupid because it depends on who. If a conservative leaked it to enshrine that opinion, they didn't want. There might have been somebody on the fence and they leaked it. And now you can't change it, right? Or if a liberal leaked it because they're trying to pressure someone, right? It really depends on who leaked it for if it was stupid or not, right? Tactically,
you would agree that it would be smart if it was a conservative did it, and it would be stupid if it was a liberal.
Well, it depends on who's on
I
the
think it's stupid both ways.
Well, no, I think it's very smart if you're a tactically, because if you leak it and that opinion changes, holy fuck. Well, I'm about to start protesting every single Supreme Court justice. I'm about to start writing letters, because now you know these people are susceptible to political pressure. Because holy fuck, they flipped on a watershed.
Even though you don't know, right? Even though you don't know for sure.
That's the issue. Yeah, if it changes.
I was gonna say. Would you think you would have to also then impeach a justice if you know that they changed their mind based on the backlash? Because then they're extremely
well, no, because we don't really know why. We don't know why they changed their mind. People do change their minds. There might be something legitimately on the fence, but the leaker.
Well, we know that in Casey it was a last minute mind change.
Casey was a last minute change. The Affordable Care Act one was supposedly a last minute change. So I think Obergefell might have been, or I'm not sure about that one. But some of these cases are last minute changes. And there are actually evidence that some of these cases, there's a draft majority opinion that goes around, and at the last second they change, and the dissent looks like a draft majority. It looks like a majority opinion because it originally was a majority opinion. Yeah.
Well, and that's like we got to remember when they vote, because remember they voted 15-week ban, yes, no, and then they spent all this time arguing why. So they voted in like December originally, after oral arguments, is when they originally vote, and at least 5 justices said a 15-week ban is okay. But we have no idea why they said that. And they've been trying to make an opinion to justify why they've said that this whole time. And now we're just like in this awful in-between area where if it looks different, that's fucked. And if it looks exactly the same, then that's fucked too.
Because we don't know if it was a conservative to cement it. But my point, Destiny, I don't know if it was a liberal clerk or a liberal justice or a conservative who leaked it. But the only reason why in my video with you I said that I think if I had to guess I would say conservative is because it just seems so smart tactically if you're a conservative, and it seems so dumb tactically if you're a liberal.
Yeah, and I don't think there are stupid people in the Supreme Court, regardless of how you might feel about the rulings or whatever. So yeah, it seems, damn, that's a. But if a clerk leaked it, that's pretty shitty too. But not as bad as a justice.
That's super fucked. The only person I'm confident didn't would be the Chief Justice. Anybody else is up for grabs.
The leak, I think, is bad.
Yeah,
I don't think it's like justifiable to defend the leak. Really.
Does this become do we set a precedent that this is like a thing now that journalists are going to start snooping around looking for
really bad?
Yeah.
Everything that stare decisis is there for, which is to ensure the legitimacy of the court and to try to separate it from the whims of politics, is also undermined by leaking this opinion in the same way that the stare decisis factors point towards upholding Roe. And so I think that it's bad that this opinion was leaked, no doubt.
I assume that the draft opinion will be changed, but only with like an addendum saying something
Well, it
about.
definitely won't say we don't know what's going to happen.
You think they're going to mention it?
Yeah. Well, I think that they're just going to mention something about the leak, just to say that this was like completely unacceptable, and just so that they have like some sort of like voice in the opinion about the context of what happened.
And maybe
Yeah, but the
something
problem
to the
is that,
effect
like-
of we can't let the public pressure change us. We saw what happened, and we have to stand by.
Yeah, but like
maybe.
this is the pressure. It's like it's like when a boss propositions an employee for sex, right? Like if the employee doesn't know if they can say no, you can never truly know what's happening in that interaction. It's the same thing here. We never truly know, right? Now we've undermined, no matter what the court says. Maybe that decision would have changed, but like we can say that justices aren't political, but they're definitely susceptible to their perceptions in the public, right? And you might have somebody that was on the wall about changing their opinion, and man, you know what? These motherfuckers, if I change my opinion, it really is going to look political. I don't know. I think I'm going to keep it. Like, I think that's within the realm of possibility for a justice, just to avoid that perception of being highly political. Or maybe not, but we have no idea, right? That's
Really bad.
Yeah.
So Destiny,
What?
it's time.
For what?
Roe v. Wade should not be overturned, correct?
Well, arguably Casey did already, right?
No, yeah, I was saying, yeah, hold on. Yeah.
All right.
Maybe just ask: should there be a fundamental?
Should there be a fundamental right to abortion? Let's answer both these questions. So two.
So here's
we'll do the actual rightness. And then the
without me
start
getting super deep into it or whatever, based on the little that I've read of the reviews of like Roe and Casey, they seem like not the best rulings to me. But because of the importance of the integrity of the courts, I think that ruling has happened. There have been like legislations written across all these different states relating to this. I think you stick with it, and then in the future, either congressional legislation is passed or something else challenges it, and maybe in the future something else is looked at. But broadly speaking, at this point, to overthrow it seems a bit undermining of the court, is kind of how I feel, regardless of if the original rulings were that good. It's kind of where I'm at.
That's a win in my book.
If the court changed their mind, do we think that would do as well? Even maybe not as much damage, but like a lot. Like if this came out and it was like, nope, 15-week abortion ban not allowed. Like, what do we think happens then? Like,
wait. If the court rules that they don't overturn Roe v. Wade, but
they don't overturn Roe v. Wade, let's say they keep everything exactly the same.
Yeah.
Like, can the court survive that amount of stench? Like, are we now really in damned if we do, damned if we don't? Overturning it destroys legitimacy. If they go back on this draft, does that destroy legitimacy?
I don't know.
In the eyes of the people.
I mean, the fact is, it sucks Nick said this, but it's actually super true. Normal people already think that, like, you have 4 Democrat justices and 5 Republican justices, well, 6 and 3, and that they go and they talk to Trump, and Trump says, you need to get rid of abortion, and they write, we love baby. Like that, most people already think that the Supreme Court is a highly political body, especially given what's happened recently with RBG and her death, and like you should have fucking retired, and like, so yeah, I mean, like, I think unfortunately citizens already now, just because the perception is that it's a highly politicized institution, doesn't mean that their rulings are at least like politically oriented like that. But if the perception is
or that you should go the other way up, up the ratchet, I would say that it's like a scale. Mm-hmm. It's not just are you political or are you not political. Everyone agrees that the court is somewhat political. Of course,
yeah.
The question is to what extent, and just because we have this perception doesn't mean that like you'd put it on NOS if you started doing things way more political.
Yeah, exactly.
Like let's say that in the majority opinion, they're like, make America great again.
Yeah.
This ruling is mandated by God Emperor Trump.
Or you've got justices on their like verified Twitter accounts, like tweeting out like,
exactly. That would
white
make
supremacy we need to deal with in the United States, and I'm going to get it on this next ruling. God help me. Yeah.
Yeah. But yeah, thank you for having us on, Des.
Yeah, this is a fun conversation. I appreciate all of you coming.
Yeah, no, it was great. Thank you.
Yeah, I appreciate it. It was a lot of fun, even though I didn't talk much.
Yeah, stay safe. Be careful. I love y'all. How much time has to pass for the ruling to not undermine the court? There were 3 or 4 factors for stare decisis. I don't know. You go look at it. But I mean, it's going to be like it's going to be a matter of like how many times has a ruling been reaffirmed? How much stuff has built on that ruling? I think that's what it means when you have a case, it's a watershed case. The idea is that like from this case stems all of these other implied or unenumerated things or these other precedents, and then these other cases build off of it. Like, so if you undo like one case, you've like axed like 50 Supreme, or not even, but like 5 or 10 big cases. I think that's what people mean when they talk about like a watershed case. Like there's a bunch of other stuff that's kind of resting on the concepts set forth from, or the legal precedents or the legal whatever that have been established in prior cases. Maybe next time you can get more lawyers with experience as opposed to 18-year-olds. I could be wrong. I could be totally wrong on this. And I admit that I may not know, but I think that if you want to have like debates about like shit like this, I think that like 25-year-olds probably your best bet, because a lot of the times, because I've talked to and I've known older lawyers like in their 30s and 40s, but usually like when I ask them questions like, what do you think about this or whatever, like I hear them say things like, bro, con law, I took that shit like 30 years ago. I don't do anything with that. Like I do corporate shit now. I don't know anything about like any of that bullshit, right? That's now, maybe that's not true for all lawyers. Maybe that some people are different or whatever, but like when you become a practicing attorney, like you don't remember every single thing you fucking learned in law school. You are like, you're in whatever area of law you practice, and it might not have anything to do with the vast majority of law in the United States, depending on, you know. Are most things discussed tonight things that any lawyer should have been educated on to get where they are? I know all opinions aren't of equal weight, but is any of this knowledge common, or is it a hobby for them? For these guys, well, these guys were all kind of younger, I think. And then Nick, I think, does like YouTube stuff where he's talking about a lot of this stuff. But I imagine like if you're a practicing lawyer and you don't like do law as a hobby, then there's probably a lot of shit that you forget. You might not remember, would be my guess, right? Do you think this will ultimately motivate a blue vote turnout? Maybe. I mean, that's the downside for conservatives, is that if they do get this ruling that they really want, it might be the case that this is what mobilizes Democrats to vote. But we're still like how many months out for the midterms? Maybe people won't remember. Who the fuck knows, you know? Do you have any VODs with women speaking on the subject? No. I have one friend who is a lawyer, but she is very conservative. So my guess is going to be that she would come down very hard against Roe v. Wade, which I guess doesn't necessarily matter, but it would be weird if like I finally have a woman to talk about it and she's like anti-abortion shit. So, but she's like a hardcore Southerner. So. When it comes to an expert arguing something even different from topic is still interesting and insightful. Maybe, yeah. I will say having these guys arguing with each other is infinitely more entertaining to me than like hearing people like just scream at each other about something being evil or whatever. I don't know. It's like, Jesus Christ. Are you going over Merrick's analysis of the abortion case? No, because we are taking a 1 to 2 month break on breeding incels, because you guys have become way too incelly, all right?